Item number 287. This matter appeared as extension once your lordship. Since the interim order already expired, your lordship is of the opinion your lordship will take up the main matter. Thereafter, the business of the court will not permitted the matter to be taken up. I filed an application for extension. Next week, the last chance is being given. I already mentioned
the impugned order.
Impugned order allowing an application for amendment, though previous like that paragraph, which was specifically turned down by the previous order by the learned court below, which attained its finality.
Who is appearing for the
I have given notice. Earlier, Wednesday, this matter has been mentioned before your lordship. But again, I am mentioning because the learned
Wednesday you have mentioned.
Yes, already mentioned. Upon notice. Today, I am just handing over the slip so that on Monday the matter can be appeared as extension. I filed an application.
287 Monday extension.
May I be permitted to mention, item number 377.
Yes.
In the list, my lord, is a contempt rule. Your lordship was pleased to issue the contempt rule.
377.
377.
Yes.
My lord, against the municipal commissioner, who is present in court in terms of the notice, my lord, being served upon him. My lord,
today is the date.
Today is the date. That is the reason, my lord, Mr. Commissioner has come, my lord.
Mr. Ghosh, who is appearing for the other side? 377.
Municipal Commissioner is very busy, my lord. That is why he requested me. Since Municipal Commissioner is very busy, my lord,
yes, yes.
He requested me to be here, my lord. That is why.
So please wait after the to be mentioned. I will be called.
Your lordship, you may kindly be fixing another matter in different courts. Because of Mr. Ghosh's request, I am here. Time may.
377 ta din to. Let the file.
Yes.
Let the file be brought out.
We are subject to your lordship. Your lordship. Your lordship, for upgradation, your lordship.
Upgradation, have you mentioned?
No, your lordship.
Wednesday, please come on next Wednesday.
Your lordship, your lordship was pleased to give me liberty to mention. As 2 times I mentioned this matter. 370, my lord. This is an application, my lord. We are done.
370. When have you mentioned?
I mentioned because this lordship application is here for restoration, my lord. On the
for restoration, it's appearing in the application. Please wait. I will indicate I will indicate a date when the applications will be taken up. I will fix.
Will not be taken up.
I will indicate a date when the applications will be taken up.
Indicate the listation.
I will indicate a date when that group will be taken up.
Date, that is why I was mentioning this matter.
When is the date fixed?
Monday is the date. That is why.
Right.
Since the last Friday, I am trying to make this application.
Yes, it is appearing in the list. I will consider that.
At any time,
next week, I will be fixing a date for that group. Yes.
Motion stage, this is motion stage. Motion stage.
Mighty, what can be done? Your junior, someone has to be present. So,
unfortunately, it is very much urgent. That is
all right. I will take it up in the next week. Yes. Yes, Mr. Go.
Well, I am submitting, my lord, that this is, my lord,
what is the order?
Overtime allowance relating to overtime allowance to be paid to the persons, my lord, working in the...
Any appeal pending?
No, appeal, my lord, everything has gone, my lord. Now the order has, my lord, after that, my lord, order has been complied with, as I am told.
Order has been complied with?
Yes, I am told, my lord, that Mr. Chakraborty will, my lord, ascertain from his, my lord, client.
Then you file an affidavit of compliance.
And the payment, my lord, I am told, my lord, the payment which is required to be made, that has also been, my lord, already disbursed.
Mr. Ghosh, file an affidavit of compliance.
That could be done. There is no difficulty.
Please take the microphone. Please
use. Factory accredited matter, my lord. The Chakraborty,
Mr. Ghosh says that the order has been complied.
The order has been complied to a limited extent. My lord, limited extent because.
Come with the, let me reserve his, my lord, the energy, my lord, to argue because let me come with the affidavit of compliance.
My lord, similar
been paid, my lord.
Mr. Ghosh, if please look into this. If it has Mr. Chakraborty says something that's been partly complied with.
I will have a discussion with my learned friend, my lord. If he say something, I will convey.
Mr. Chakraborty, indicate to Mr. Ghosh, according to you, why, according to you, it is not.
But I will indicate a second. I will indicate it, and openly I am indicating the similarly the other, my lord, the employees, it is not extended to them. My lord, the factory, those who are working in the factory, they have to give this benefit, my lord.
Please look into it.
They have to give this benefit.
Please look into it. If according to you, it has been complied with.
What is very well, I understand, my lord. I will answer, my lord, the next occasion when the matter comes. Because I followed, my lord. What is
how soon can you file the affidavit of compliance?
Your lordship, my lord, gives me at least, my lord, 2 weeks.
Why 2 weeks?
Your Lordship,
It is up to Supreme
Your
Court, my
Lordship,
lord. Finally,
No, no.
When the order was passed,
in the year
Now the
2022.
situation is that Mr. Chakraborty cannot say that no payment has been made. Now, my lord, payment has been made. Now he's something to say. That's all right. But I will say, my lord, how the payments have been made to the petitioners.
let Mr. Chakraborty indicate to Mr. Ghosh so that in the meantime he can take instructions.
Line may kindly be inserted similarly placed.
No. That could be, my lord. What is your lordship's order? That is the order.
That I cannot, you can indicate it to Mr. Ghosh. Mr. Ghosh can consider that. And if it is an arguable matter, I will consider
The
that.
question is, my lord, what is your lordship's order? The petitioner before the lordship is confining to their I understand, argue on that.
That cannot be modified now.
That cannot be modified.
In service
Let
matter-
the my lord dispense with and let me come with the evidence compliance, then your lordship consider it.
In service matter, if one employee extended a particular benefit, that should be extended to another.
Yes, but rule was
Similarly placed.
that is the reason your lordship, my lord, the Mr. Commissioner is present.
Pursuant to the
This is appeared at my instance, madam. On the 26th of June 2025, madam, what has happened, madam, I was stuck before a different court and my learned junior has paid for a time. And my learned junior has paid for a time.
yes,
Thereafter, the learned advocate for the opposite party had appeared and had obtained an order that is at paragraph 3. It is, however, made clear that the pendency of the civil revision application shall not preclude the learned workup tribunal from proceeding with the hearing of the OA 28 of 2022.
yes.
Now, my lord, in the meantime, I will kindly see the order. There is no appearance of the opposite party advocate and no wakalatnama has been filed in the department. Now, in this, what I have challenged an order dated 19th May 2025.
Yes.
What has happened, my lord? They have filed, the opposite party number 1 has filed OA number 28 of 2022. Now, I have alleged that the applicant is not present while filing this and the signatures are not matching. I have obtained a PAN card of the opposite party number 1 and I have attached with the application to decide the preliminary point first before hearing of the OA number 28 of 2022. I have filed an application. That application was rejected. And previously also I had filed an
What is the
application.
application which you have filed? Where is that?
Yes, my lord. This is the affidavit of service. I've complied with your order, my lord. I've served directly to the party. Opposite party number 1 and 2.
Yes.
Kindly-
Yes. Where is the application? দেখে নিন ওটা সার্ভিসটা দেখেন।
And the application is appearing at page number 11.
But I'm appearing on behalf of the opposite party.
Yes.
No wakalatnama has
Why would not file your wakalatnama?
But Wakalatnama has been filed. It is showing in the official website.
But after that, thereafter not filed, my lord. After filing but I filed the affidavit of service when I am filing.
That is a different thing altogether. You should have checked up before
But I've
making.
given a copy, my lord. I've served upon the opposite party number 1.
Please give him a copy.
Only fix it for hearing, and my lord, the next date for hearing of the OA number 28 is 17th of July. My lord, I'm only praying that this order may be modified, my lord, or else this will become infructuous, my lord.
My lord,
What?
it has come up for correction and not for
For
modification.
correction, my lord, I have mentioned the matter. It has wrongly gone down as correction. It has wrongly gone down as correction. And learned friend was served a notice also for mentioning.
Where is your mentioning slip?
Yes, my lord, I have it. This was the mentioning notice that was sent. It was sent to the learned
No,
friend.
I have got the mentioning notice.
Yes.
There is no dispute about that. But the question is,
Sir,
what
it
was
was
there?
by mistake. It is appearing under the heading.
Yes, my lord, because my
Correction.
lord, on
Who has written this? It is whose handwriting for correction?
I not mine, my lord.
Yes, the person who mentioned. He or she told that it is for.
But I had personally mentioned the matter on 9 July. My lord has directed only to
It's
the
not
matter,
for correction.
the matter to be appeared on to be mentioned, not for correction, my lord. Only the matter to be appeared as to be mentioned.
Yes.
Probably I was also little surprised that what correction it
Yes,
needs.
ma'am. There was
because
no
there are
correction,
no
ma'am.
corrections to
All
be
right.
done.
Yes. What is this matter about?
My
What
matter
is the
is,
application?
my application is at page 11.
Yes.
And I previously filed an application to decide the preliminary point.
What is
There,
the preliminary point?
that the applicant has not signed the opposite, the OA that has been filed, the signature that is appearing in the OA, that is the application
Who
under
is the applicant? You are the applicant.
No, my lord.
He is for the
Opposite party
applicant.
number 1, yes.
Yes.
My
How
lord,
do you know that the applicant
But
has
I've
not
got-
signed?
Yes, my lord, I've got a PAN card of his.
Yes.
In the second round, I've got a PAN card, and my lord, from the signature that is appearing on the PAN card and the signature that is appearing on the OA is different. And my lord, the applicant resides in Bihar, and the applicant has to come to West Bengal before the Oath Commissioner for filing this application. And I have stated in my application preliminary, I have taken it that they were not present in Kolkata while filing this OA. This has been done by the relative of the applicant. That was my issue. My lord, the preliminary point, that order that was
What is the OA for?
removal of the petitioner
not
as
removal,
Muthu Ali.
not removal.
Setting aside of the board resolution dated 13/9.
That be decided. If the
But the
all points will be decided in the OA.
and only one thing, Malaru
Because,
order dated at page 17 once. At page
Yes.
17.
Yes.
My
But
lord, if I may get the copy of the civil.
I have given a copy. There, no name was in the order dated Malaru 26 June. How can I find
I
it?
appeared on.
How can I find it? I do not know your name. How can I
Please
give
take
you?
your seat. Please take your seat. Yes.
Malaru, kindly see page number 17 once.
Yes.
But in that, before I filed one application that was on 2024, this application was rejected. There it has been ordered that the respondent is at liberty at the time of hearing of main application to agitate this issue, my lord. It was given,
Page.
page 17, my lord.
The respondent is at liberty to agitate.
At the time of hearing of the main application. My lord,
What? Agitate what?
this issue, my lord.
Yes.
This issue of point, this order was of 18 September 2024.
Yes. Have you
But
challenged that order?
No, man, that order has not been challenged. Thereafter, I filed an application again.
Why?
Because my lord, the PAN card was not available with
Maybe.
me. Thereafter, I
This is the finding. So this all points will be taken up at the time of hearing.
On the
Asun, this application under Article 227.
My lord, I am appearing for the petition. In the order itself, my lord, the miscellaneous case of 66 of 2020 has been written. It should be, my lord, 66 of 2000.
Of 2000.
2000. In first paragraph and penultimate paragraph, my lord, this has been written 66 of 2000.
এইগুলো
Jit Mukherjee is appearing for the opposite party is stuck up in the traffic. My lord,
you are holding the brief of Mr. Mukherjee. Yes.
I'm not holding. I've been instructed to submit before your lord.
Yes, yes.
There are two applications, my lord. First,
This is an extension of interim order.
this is for extension of interim order. Interim order, my lord, already expired. My lord, application has been filed upon service copy, my lord, to other side.
That
And
is impugned order.
the impugned order, my lord, allowing an application under order 39 rule 7. The, my lord, according to him, my lord, the plain case that the property in dispute is in respect of a passage there. We are saying that this is a part and
It
parcel.
was expired on September 2024.
No, my lord, December 20.
So then it was extended after
It
that.
was extended.
Yes, Mr. Ryan. When he will be coming?
What was this coming in the
His juniors have also not reached. All of them do not come from same place. Keeping it on Monday. It has already expired.
Monday. But the entire matter can be disposed.
Yes, call the next matter.
this one in this one? I'm appearing for the petitioner.
Petitioner. Yes. Interim order was still.
Up to May. It was
Yes, Mr. Rai. Why you will extend it? Expired long back.
May 2025.
Yes.
And they
Now we are in
filed an
July.
application. We have already filed an application before expiry of the same.
Why have you filed that? Why did you not mention before expiry? Mr. Rai, before expiry, the matters which are
All.
mentioned immediately thereafter prior to the expiry, you have not mentioned subject to correction by you.
That
There was no necessity to file any application also. So you have filed the application, kept quiet, allowed the interim order to expire. Yes, yes.
Dilatory tactics, man.
dear practice.
Yes,
There
yes.
also, my lord, here also.
Both of them.
My lord, there, my lord, in the court below also, my lord, dilatory tactics here also, my lord.
And how the fraud has been practiced, that also.
This is the
I
long
have a
time.
fix of the matter. I am ready to argue on this merit.
Ashun.
Kindly fix the date.
This is an application. application disposed of.
I'm for the petitioner, my lord. The predecessor interest of the petitioner as the Sebai of Sri Sri Ishwar Karunamoyi Kalimata deity filed two suits. One suit for eviction of the license.
What is the order on the challenge?
Well, the order 41 rule 5 was allowed subject to payment of rupees 500 only as the occupational charge. My lord, I challenge that order.
What is the suit for? Eviction.
For eviction.
Mr. Das, are you interested in occupation charges or you are interested in the getting possession? I can expedite the hearing of the appeal. Otherwise, it will be kept pending here.
No, my lord, now, my
What is the stage of the hearing of the
just
appeal?
appeal file, my lord, stay was granted. It will take time.
I'm expediting the hearing of the appeal.
Right now, my lord, it will take time, my lord. My lord, grant the copy of the copy, they let come because my lord, the prevailing rate, my lord, at least 10,000, but like only give no 500 rupees.
By the order impugned.
I am for the petitioner, my lord. Copy served, my lord. I am led by Mr. Anirudh Chatterjee. He is present virtually, my lord.
My lord, I'm sorry, my lord, my device is not functioning properly. My lord, this is with respect to
Mr.
visitation.
Chatterjee, please change your device.
My lord, I am too, my lord,
Because it's regularly happening that your device is not working.
it just happened from yesterday, my lord. I wasn't able to correct it. But
Yes.
my lord, in this matter, your lordship would,
Also, it happened.
my lord,
On earlier occasion, also it happened. Just
It's
prior
happened.
to the summer vacation.
I'm so sorry, my lord. That point of time, my lord, it was a different device.
Yes.
Now, my lord, the problem here is the court has directed visitation rights, my lord, in City Center Mall, has found that the father is flouting the order of maintenance. There is a due of about 24 lakhs, but still allowed the father to see, my lord, the child at City Center Mall. There is already an order of virtual visitation. He doesn't, my lord, and he's filed his assets and liabilities, my lord, where there are crores of money, my lord, with him. It's not that he's a destitute.
Mr. Chatterjee, what is the order which you are challenging?
But the order which allows the husband, rather the father, my lord, to have a visitation, my lord, of the physical visitation at City Center Mall.
But 13th of May order you are challenging.
Yes.
So, Mr. Chatterjee, that was for during the ensuing summer.
Yes, exactly, my lord.
Has
No, he has given, my lord. Even thereafter, my lord, the order has been passed. Looks to
show
the
me
impugned order.
that. Show me that.
Looks to the impugned order, my lord.
Page 20, my lord. Page 20, last paragraph.
No, Mr. Chatterjee, it's for 1 month, 13th of May till 16th of June, 2 months of each week, up to 16th of June. So
Yes,
that
my
is Mr. Chatterjee.
No, my lord, thereafter, if your lordship sees to the ordering portion,
Yes. What
now
is
I am challenging this, my lord, because of the consequences that I might face as well. I am on that as well.
no?
Can we have a look at
Which portion affects you?
the entire portion? Have a look at the last part.
Yes, please place that.
I have gone through the decision carefully. It appears that the referred case arose out of that's about the Shahu matter. In view of the above, the prayer for petitioner for access of the minor child during ensuing winter vacation stands rejected to date. That's not the. I'm sorry, that's not the one which I want to place before your lordship. I am on. right at the end, my lord, can I come to the end?
The strategy is still 16th of June, 2025.
20 last paragraph, my lord.
Page 20.
20 last paragraph.
What is page 20? Yes, yes, page 20. I am looking at the certified copy. Page 20 is,
Last paragraph. Impugned order.
yes, page 20 is the, please kindly come to the operating part. Operating part says, please come to the penultimate page.
Visitation, regular visitation is allowed, page 20, last paragraph, in spite of initial agitation and objections raised. Once a week, preferably Sundays from 3 p.m. to 5 p.m.
This was agreed upon. You have agreed upon. How can you challenge that?
The last portion also they are.
Sir, it's an agreed order.
But they have not, visitation has not been given, my lord, to the child. My client has not been able to.
The only difficult.
Uh,
My lord, one thing, my lord, the only difficult.
Sir, it's an agreed order. I cannot touch that. It is a matrimonial suit.
Matrimonial.
Is that the instance of the wife? And
My
is
lord,
that,
my lord, if your lordship, my lord,
yes, Mr. Chatterjee.
my lord, your lordship was passing an order, my lord. I don't know what your lordship was.
Because there's a consent order, Mr. Chatterjee, what you are saying.
My lord,
There
it wasn't, only the place of occurrence was consent, not, my lord, my lord, the visitation. It was after when she was present in court, the court asked, she just said so.
Your junior pointed out page 20, last paragraph.
Absolutely. I am also, my lord.
Yes.
I am also. It's not a consent with respect to the visitation. It is the consent with the place of visitation. Kindly have a look at it. It is a consent to the place of visitation, not the visitation itself. And he has a duty, my lord, to, and kindly looks to the last part of the order. Kindly sees the visitation would take place.
Everything on consent.
If your lordship kindly sees, my lord, the visitation would take place at City Center 1 Mall, as suggested by the learned advocate for the respondent wife in open court.
This is 20, last paragraph, the consent, timing and the day.
Millard, kindly looks to the impugned order. Kindly turns to the impugned order.
Yes, I am in the impugned order.
Millard, your lordship is looking at, Millard?
Page 20, last paragraph, which your junior has pointed out.
Millard, kindly, your lordship is looking at, Millard, order dated
13th of May 2025.
Absolutely, Millard, it was not on consent. It's just the
strategy. Please, page 20, last paragraph, please place loudly. It's a consent.
Millard, in my petition, Millard, it's right at the end.
If you say,
Millard, if your lordship says the internal order, internal page, Millard?
Page 20, 20. First page of the impugned order. If you
First page, yes, Millard.
Last paragraph.
In spite of initial agitations and objections raised by the custodial mother to the prayer for physical visitation with some intervention by the court and the positive, sensible
and pragmatic
approach of learned advocates for both the parties concerned, it was agreed. But it's the advocates. May I ask this question to myself, how is it binding upon the law?
Mr. Chatterjee, then you file an application before the learned trial judge saying that
I am not on that. I am not also on that. Kindly appreciates one aspect in the matter. Thereafter, kindly sees
that you have to say that I did not give consent. That's not your case. I did not say these instructions to the learned advocate. That cannot be accepted here. If you have to say because it happened, everything in front of the court, you go before that court and tell the court that it was not my consent.
Milord, it's a matrimonial matter. Milord, I am not going into an adversarial situation here at all.
Mr. Chatterjee,
I am not going to. I am not saying, Milord. I will not make it adversarial. Milord, I am saying the father should meet. I am not on that. Father should meet, but he should also comply.
Yes, comply.
he has not complied with his obligations at all. He
That you
can't.
take steps. You take steps for that.
It's there in the order itself, my lord. It's there in the order itself.
Yes.
My lord, my lord, your lordship knows that line of decision, my lord, but that if he is not complying, my lord, with the maintenance order, he will not have a right of visitation, my lord, ipso facto. He will have to put in the money.
Mr. Chatterjee, take out an application before the learned trial judge in that regard. The learned trial judge will consider that and pass orders.
The learned trial judge has passed an order, my lord. The learned trial judge has passed an order.
No.
Have a look at the last part of the order.
Yes, place that.
Last part.
Yes.
Last page, my lord. Right at the end.
Yes.
Albeit is not within the purview of consideration of the forum in this case, the petitioner father is hereby directed to abide by the direction of the learned additional sessions judge second court Barashat as contained by the order dated such and such passed in connection with criminal appeal number such and such by clearing up all the outstanding amount of alimony maintenance ordered against him at the earliest and go on paying the correct current amount. And he has not paid that.
Mr. Chatterjee, for that, you take out an appropriate application if he has violated this order. Take out an application for that.
If he has violated this order, my lord, he is also not entitled to the visitation rights. I want that.
Mr. Chatterjee, please take out that application. Parties are to be given an opportunity to contest that.
Lord, may I do this before your lordship, my lord? That kindly do not treat this as an adversarial.
Mr. Chatterjee, please you take out an application before the learned trial judge making this allegation. Then the trial judge will consider that.
Mr. Banerjee is before your lordship. Let him say whether.
Mr. Chatterjee, you are also not before me. Mr. Banerjee is also not before me.
Well, Mr. Banerjee is represented, my lord, by Mrs. Dhamali.
But Mr. Banerjee,
Mrs. Dhamali. Then let Mr. Banerjee come. I'm sure that he can find a way out.
70. The order is for current paying. I am.
Why are you not paying the alimony?
This is my document. Every month I am paying 30,000 for the child.
My lord, we've given a chart at page 8. Kindly have a look at it.
The page 70.
Please pay you have to pay the maintenance.
Month, my lord, for the child.
Mr. Chatterjee, there is a dispute. The learned advocate for the opposite party is saying he is complying.
So we have given a chart.
Mr. Chatterjee, if your allegation is that they are not complying, take out an application for that. Ashun.
Miller, kindly keeps it on Tuesday. I'll speak with Mr. Banerjee and find out a solution.
No.
Kindly do not relegate us to litigation, Miller, once again. We'll find out a solution here. Because if it goes down, Miller, to the trial court, there will be another round of litigation. I don't want that, Miller, for the child. I'll speak to Mr. Banerjee and find out a way.
I am appointing both of you as mediators, joint mediators.
I have no problems, Miller. Absolutely no problem.
Mr. Chatterjee, solve out this problem.
Absolutely, I bow down. I'll do that. I'll do that.
He is not allowing to see my child, my lord.
I will see to it that. I will see to it. Milord, I assure your lordship, Milord, that every solution, whichever Mr. Banerjee wants, and whichever, Milord, I can find out a way, we can find that out. Do not send us to litigation here.
Come to court.
My lord?
This type of litigation should not come to court.
Exactly. I completely bow. Milord, keeps it Monday week. Keeps it not Monday week is 21st. It will be difficult. Keeps it on 22nd. I will sit with Mr. Banerjee and find out a solution.
Why Monday week?
This Monday, Milord, I will not be able to come to court, Milord. My father's Shraddha, Milord. I will not be able. Tuesday, I have no problems, yes. But I will need, very well, I will do it over the weekend. I'll do it over the weekend.
Yes, please see to it that it is done.
Very well, I'll do that. I'll do that.
When this matter is taken up for hearing, Mr. Chatterjee, learned senior advocate appealing for the petitioner submits that the husband opposite party herein is not paying alimony and maintenance in terms of the orders, in terms of the subsisting orders directing payment of alimony and maintenance. So on the other hand, the learned advocate appealing for the opposite party submits that the further opposite party is regularly paying, is compliant, has complied with the orders with the subsisting orders of maintenance and alimony. First up, the learned advocate further submits that the wife petitioner is not allowing the father to meet the son in spite of specific direction passed in the impugned order. First up, Mr. Chatterjee prays for an accommodation so that this issue can be resolved amicably. Yes, Mr. Chatterjee, I've recorded that. First up,
Shall try.
yes, as jointly paid by the learned advocates for the parties, list this matter next Tuesday under the heading motion. Every service filed in court today is taken on record.
Grateful to your lordship.
Lord, I appear for the petitioner. Lord, the petitioner before your lordship is a plaintiff in a suit for declaration of title, permanent injunction, and recovery of possession. The order impugned is dated 25th April 2025, wherein in the first portion, the ad interim injunction granted in my favor was extended. I'm not challenging that, my lord. On that same date, I filed an application for Order 1 Rule 10 for expunging the name of one of the pro forma defendants who had died before filing of the suit, and for adding the
Suit is bad against a dead person.
no, my lord. The issue is that in the particular what happened when the suit was drafted, it was actually the fault of the learned advocate, my lord. When the suit was drafted in the tax bill, the name of the 3 co-owners was mentioned.
Sir, what is the effect of a suit filed in the name of a dead person?
My lord, over here.
Now, what is the impugned order?
Yes. In the impugned order, my application on that same day when it was filed, without giving me an opportunity of hearing, without giving the defendant an opportunity to file a written objection, it was rejected suo moto, my lord.
What is the application for?
For Order 1 Rule 10 for adding the legal heirs of the
Cannot be done, rightly rejected. How can it be done?
My lord,
suit filed against a dead person.
my lord, this is the pro forma defendant. This is not the principal defendant, my lord.
Then you don't need to add the heirs.
Only the
if you say that they are not necessary part, you did not add them.
The only necessity is since it's an unpartitioned property, my lord, that is why they are necessary.
So the suit is bad. You cannot take both these, please. You cannot say no, since they are not necessary parties, suit cannot be said to be barred, and then again say, yes,
the learned court has not held that the suit
cannot go side.
The learned court has not held that the suit is barred. The learned court has held that this cannot be done by way of an Order 1 Rule 10 application.
Cannot be done, right?
It has to be done by a substitution application.
That also cannot be done.
My lord, I have a judgment of the learned of the apex court, my lord, which says that if there is a bona fide mistake at the time of filing the suit, yes,
suit filed in the name of a dead person.
Yes, my lord.
Which paragraph?
Yes, my lord, kindly takes up. But paragraph 19, my lord.
19.
19. Lord, my lord, since the
by
My lord, I am for the petitioner, my lord. This is an application for expeditious hearing, my lord.
Of what?
My lord, the petitioner is filed in the year of 2019 for a declaration of suit for permanent injunction in the suit property, my lord.
What is the application which is pending?
My lord, title suit, my lord.
No, no, no.
The application,
19th of February 2025, an application has been filed. What is that application for?
for an injunction application, my lord.
19th of February is the injunction application.
Injunction of what?
This application under Article 220.
For the opposite party, my lord. I am on caveat.
Yes, who is for the petitioner?
Lord, I beg to appear, my lord, on behalf of the opposite party.
My lord, I am led by Mr. Chatterjee, my lord.
Yes.
Also Mr. Mukherjee. My lord,
Mr. Samanta is not your petition.
no, I am not the petitioner.
Hmm.
I am led by Mr. Chatterjee.
Yes. Who is for the petitioner? None appears for the petitioner at the time of call. No
lord.
accommodation has been sought for either. The opposite parties are represented by their learned advocates.
Copy has also been not been served.
It's okay.
The learned advocate appearing for the না কি বললাম by the learned advocates. First up, the learned advocate appearing for the petition, opposite party submits that no copy of the civil division application has been served upon the caveator. First up, however, since the petition is not represented, CO number such and such stands dismissed for default. Great, next.
Grateful to Lodge.
Well, my lord, I am appearing on behalf of the plaintiff petitioner, my lord.
Yes.
My lord, suit for declaration and injunction. My lord, the petitioner filed a suit for declaration and injunction and also filed an application for ad interim or injunction, my lord. Initially, my lord, ad interim injunction was refused. Challenging the said order, my lord, the petitioner preferred misappeal. Misappeal also dismissed, my lord. challenging the said dismissal order, my lord, I have come before your lordship.
Ad interim refusal.
Yes, my lord.
So I'm directing the temporary injunction to be disposed of. Both the courts have rejected the application
in-
at interim stage.
Yes.
So I'm directing the,
In the meantime, pass order of injunction, my lord. Otherwise, my
both
building
courts have refused.
my lord, if your lordship kindly consider, my lord,
Both the courts have refused.
my building will be demolished. If your lordship kindly, my lord.
That cannot be a ground. If it's an illegal construction, it has to be demolished.
My lord, in the plaintiff, my lord, purchase the property along with the construction, my lord. My lord, thereafter he filed.
Sir, if you want me to go to the merits, I will go to the merits and decide that. Choice is yours, or I will direct the temporary injunction. Have you served the copy upon the other side?
This divisional application.
No. The injunction application
Yes, my lord.
for the trial court.
Trial court, I have.
They have appeared.
Appeared also.
What is the next date fixed? What is the next date fixed for hearing of the temporary injunction application? I am not in the miscellaneous appeal. Temporary injunction application, what is the next date fixed?
That date has not been, my lord. Don't, my lord. My lord, if your lordship kindly give me leave, my lord. Otherwise,
satisfy me that you are entitled to an order of injunction.
my lord,
Show me.
The petitioner
Sir, injunction, interim order is not a matter of right. You have to satisfy. So if you can satisfy, yes, you are entitled to an order of
my
injunction.
lord,
Yes.
my only submission is that, my lord, in the year of 2018, my lord, the petitioner made an application along with as-made plan. That has not been considered as yet. Either reject or allowed, my lord. My lord, thereafter, my lord, the petitioner.
As-made plan means there is violation. Where is the provision of as-made plan? Howrah Municipal Corporation.
Yes, my lord.
Yes, show me the provision of as-made plan.
There is no provision, my lord, but
That is why, so if you want me to enter into that, I will enter into that. If you want me to enter into that, I will enter into that. Without any provision, how can you pay for sanction of that as-made plan?
my lord, the petitioner, my lord, has not made any construction. He purchased the property, my lord, in the year of
You have to have checked
2001.
up, you have to have verified before purchasing whether it's a legally constructed building or not.
My lord, kindly give me interim protection, my lord.
No,
for a
no.
limited period, my lord.
Unauthorized construction, no. Not in this way. Or I can direct, that is why I told you, temporary injunction I can direct to be decided, but no protection now. After some argument, the learned
I am for the petitioner's defendant in the law. Plaintiff have filed the suit for partition of the property, claiming themselves to be the joint owner with me, but no document has been annexed with the plaintiff.
No, I could not follow.
Plaintiff have filed the suit for partition of a property in which he has claimed himself to be a joint owner in respect of the property with me. But no document has been relied upon by the plaintiff in the plaint. Neither title deed nor genesis has been stated in the plaint. but I have filed the application under Order 7 Rule 11 that has been rejected. The trial court has traveled beyond the plaint. They have considered the document which has not been part of the plaint at all, my lord. My lord, can you come to the impugn order, page number second page, my lord, of the impugn order, my lord.
Show me the plaint first.
My lord, page number 19. It starts from, my lord, page number 14.
Page number
14, my lord.
14.
14. My lord, on the 15 is the first paragraph, my lord. And paragraph number 2, my lord, the plaintiff having undivided 1/4 share, and the plaintiff number 2 has the having 1/4 share, defendant number 1 having 1/4 share, and defendant 2 is also 1/4 share. My lord, the plaintiffs and the defendants are governed by the Muslim law, my lord. If they have the 1/4 share, it means they must have the title deed. Otherwise, 1/4 share could not be a 1/4 share, my lord. No such document has been pleaded in the plaint, nor it has been listed in the document, my lord. No jural relationship have been pleaded in the plaint, my lord. What is the jural relation between the plaintiff and the defendant, my lord?
Yes.
My lord, can you come to, my lord, impugn order, my lord, once?
Yes.
Second page of the impugn order, my lord. My lord will find that WS is
page.
filed.
Yes.
But I have filed the WS before passing of this order, my lord.
But you say that no other documents excepting the plaint can be looked into.
My lord.
So your WS also cannot be looked.
Not but my lord, kindly see second line, by subsequent line. Copy of the property tax receipt for 2021-22 filed showing the name of the plaintiffs and defendants.
Which poster you are pressing?
That impugn order, second page,
Second page.
first line, my lord. WS is not been filed, copy
Yes.
of the property. They have a copy of the property of tax receipt for 2021-22 is filed showing the name of the plaintiffs and the defendant. Whereas in the plaint, there is no no document, there is no list of documents.
So the learned trial judge could not have considered these
This
tax
document,
receipts.
tax receipt.
Anything more?
No, my lord.
This application under Article 227 of the Constitution.
My lord, I'm appearing on behalf of the petitioner, my lord. Mr. Shubhankar Nath, he's on legs in another court, my lord, I'm proving the application.
Yes.
This is an application for expeditious hearing of a lease appeal, my lord, 113 of 2022, which is pending before the City Civil Court.
What is
Third
the,
bench.
what is the stage of the
My lord,
8th of July? What happened?
8th of July, adjournment was taken by the
What is the next date fixed?
12th August. My lord, several orders have been passed by various premises of
Give me the parent order. Bhagirath Kejriwal or something.
The decision we are relying upon is passed by your lordship.
Bhagirath Kejriwal.
Yes, my lord.
Yes, Ashu. This application under Article 227. Light of that. Yes, next. Yes.
For the
Yes,
petitioner,
Mr.
my lord.
Das.
So for declaration of permanent injunction, plaintiff is the petitioner before lordship. My lord, the defendant, after getting ample opportunity, did not submit the written statement. Learned court rejected the application lastly after 4 times that should to be hard expertise and they have lost the chance to file a written statement. PW1, PW2 completed. On the date of PW3, the defendant appeared and filed an application for setting as an expert hearing of the suit and acceptance of the written statement. Learned court without, there's no application for condemnation of delay. Learned court without giving any reason accepted the same and allowed.
By the order impugned. Yes.
Mr. Shonak Bhattacharya is appearing on behalf of the petitioner. Mr. Shonak.
Since I'm not inclined, since
Item number 17, my lord.
Is a lordship. I am for the petitioner before.
Like lordship appeared in connected matter on the behalf of the petitioner in the earlier
since
17, 18 and 19.
since
Short, Shubhar, my
who is the senior counsel?
পার্থ চক্রবর্তী পার্থ চক্রবর্তী
This application, this application.
My lord, I am for the petitioner. I am being led by Mr. Jantanan Chatterjee. I am for not paying for not today.
on the prayer of the learned advocate for the petitioner.
Grateful, my lord. My lord, item number 22, I appear on behalf of the petitioner plaintiff, my lord. Before I proceed with the matter, my lord, inadvertently I have written the order dated 18th June 2024. It should have been 18th June 2025, my lord. My lord, kindly
On the
grant me
prayer of the learned advocate for
hearing stage, my lord. I have filed an application under section order 21 rule 1 stating
Order
my
26 rule 1.
order 26 rule 1 stating my age old ailments, my illness, as well as I am one and sole witness in the matter. I am the widow lady, my lord. That has been turned down only by taking my medical document into consideration and discarded my and my age factor has not been taken into consideration at all, my lord.
The medical, sir. Age factor. So if you are you
75 years old, my lord.
maybe 75
widow
years
lady.
old. Sir, have you not seen the learned advocates, senior advocates? More than 72 years, regularly coming to court, arguing.
She's staying alone, my lord.
But
Kindly.
the age which matters is the physical condition. So if the medical report says, medical document says she is full, full fit physically. So
my lord, age is old age ailments is also one of the infirmity, my lord.
show me the medical documents which you relied upon.
My lord, yesterday I have been treated. 1 month's bed rest have been
so after 1 month you will give evidence.
My lord, kindly.
Where is the medical document? Show me which you placed reliance upon.
My lord, page 55 is my application. With that application, I have annexed the my lord 55, 56, 57.
Where is the certificate of the doctor?
58, 58, 59, 60, 61. This is the doctor certificate which was.
Sir, where you are asked to advised to take bed rest for 1 month? Where
1 month that was yesterday.
That was not placed. Show me from the documents placed. So that
12 or my lord, page 60.
Page?
Page 60.
Page 60, yes.
My lord, rest for 7 days.
Yes, 7 days.
My lord, my lord, the condition of
that was due to fever, weakness.
Yes, my lord. My lord, weakness, fever to a 75 years old lady, my lord. Kindly, my lord, kindly do not, my lord, kindly seize this factor into consideration, my lord. A 75 years old lady staying alone, widow, my lord. Her daughter has daughter is staying in her in-laws' house, but she's staying alone, my lord. I believe, my lord, she is the sole witness who will be protecting her property, my lord. Property has been, they have produced a gift deed executed by their mother, which is under challenge in a suit for partition, my lord.
Sir, 1 day you will go, give evidence, cross-examine, you can come back.
My lord, kindly fixes any date so that
which day may be appointed, my lord? No, not appointment. Court 1 day. You are not going to the doctor.
Not fit, my lord.
You are not going to the doctor. Where are you going? Where are you visiting for treatment?
My lord.
Doctor, where?
My
The
lord,
doctors are coming to your.
my
Sir, doctors are coming to your residence.
lord, kindly take up my pleadings
I
in
think
paragraph.
you have gone to government hospital
My lord.
from your home.
My lord, kindly
The
take
doctors have not come to your residence,
kindly.
so you could go there.
Kindly take up page 10 of my civil division application, para 8 and 9. The petitioner plaintiff is a 75 years old lady and is a widow lady, resides alone at her residence. Her only daughter is married and stays at her matrimonial house, and she too is presently suffering from illness. Para 9.
Who accompanies you to hospitals?
No one. I'm staying alone. I have to take care of myself, my lord.
1 day. 1 day you go to the court.
My lord,
cross-examination will be completed on that day.
Gift deed is under challenge. My lord. Would it be possible within a day to
How many days you want?
My lord.
How many days you want?
My lord, that, my lord, she
Executive dates or 1 day in a week?
if certificate medically unfit, my lord, that if my lord
Show me the medical advice of the doctor.
yesterday, my lord. My lord,
So purposely, because this matter will be coming up today,
at the bottom, my
I will
lord.
summon the doctor.
No, no, release, my lord.
I will summon the doctor.
Kindly, my lord. And today is the date fixed before the trial court below, my lord.
Bed rest for
1 month, I believe. At bottom portion, my lord. Bed rest.
see, what is the ailment?
My lord,
Sir, what is the ailment?
joint pain, old age ailments, my lord. These are the issues, my lord.
Yes, yes,
These are the issues, my lord.
yes.
My lord, I have annexed her voter ID card and Aadhaar card to
Not,
show the.
I'm not disputing
my lord,
for a
I'm
moment your age.
relying upon a judgment, my lord, which says, my lord, not only the illness, my lord, age-old factor is also one of the ailments.
So it seems you are not willing to adduce evidence.
My lord, I will, my lord. Kindly grant me 3 months time
For what?
for adducing evidence, my lord.
In court.
My lord, kindly appoint someone, my lord. My
Why?
lord, kindly passes a direction so that someone may be appointed and paragraph 11, I believe, my lord. This is the case opposite to this case, my lord, because the learned trial court below has decided, taking into consideration all those factors into consideration, that
is
was
why-
under challenge, my
That
lord.
is why scope of interference is limited. So only whether the order, propriety of the order, that was considered. Any jurisdictional error. So that is why the coordinate bench refused
There
to
were
interfere.
other pleadings
And
as well,
here
my
is
lord.
the other way around. The learned trial judge, if I apply this principle, then 227.
My lord, the learned
May not
trial,
be
trial
interfered.
judge below has not taken into consideration the other factors.
What other factors?
My lord, my age, that has not been taken into consideration. Kindly seize my application, my lord. My lord, at page number, application is at page number, my lord, 55. 50.
Give deed in whose favor?
In favor of defendant number 4 to 5 to 7, who are
So
my
who-
brother and sisters.
So brother and sisters, you have gifted, allegedly
My
gifted.
mother has gifted, that is their pleadings. Pleading of the defendant that the entire property.
So what is the date of the gift deed?
2008. I was not aware of it. I filed an application for amendment after I came to know. That was turned down. I filed a civil revisional application and that has been allowed by Honorable Justice Vishwajit Basu. My lord, I have annexed the order as well, my lord. And there is an order passed in the another civil revision application filed by the defendant seeking for expeditious disposal, wherein Honorable Justice Shampa Sarkar has directed to expedite the suit and dispose it off within a year, my lord. That is also influencing the learned trial court below. That is the.
Sir, you should be ready because you are the plaintiff.
My lord, my
should welcome that. It seems that you do not have a good case on merits.
No, my lord. No, my lord. I am willing to protect my. I'm a alone lady, my lord. I'm fighting for myself, my lord. My lord, kindly take these factors into consideration, my lord. Everything is on pleadings, my lord, on record, my lord.
Nothing is on record.
My lord, kindly take up my
Nothing is
application
on
page
record.
55, page 55. That today is fixed for preemptory hearing of the suit. That the petitioner is about 75 years old and suffering from old age ailments. That this intense summer season, her doctor advised her the plaintiff to take bed rest at home due to her serious illness. That hence, if she appears for evidence personally before the learned court, it would be fatal for her at any moment. Your petitioner may not sustain.
So from the clinical notes, your complaints, so it was not referred to the specialist. You went to a general physician medicine.
My lord. My lord.
So if the problem is so serious, should not have gone to a general physician medicine.
Staying alone,
Because
my lord,
the
suffering
clinical
all these traumas, my lord. Kindly take, my lord, kindly.
That is not the advice that you have to go to another specialist or something, because clinical.
Everything might not be reflected in the doctor's prescription, but there are certain emotional.
But you are trying to.
My lord, no, my lord, not at all.
We cannot go by emotions. Court cannot go by emotions.
My lord.
Court cannot go by emotions.
My lord, I am willing to proceed with this suit. My lord, kindly grants me 2 months time and direct the trial court to appoint someone.
No.
My lord.
That is not.
My lord, kindly give me reasonable time period so that, my lord, even
for what?
to adduce even if my lord is willing to reject this, my lord, civil revision application. Let me-
When can you appear before the learned trial judge?
2 months time may be given, my lord, 2 months time, and this might be kept open. That
11. Today is the date fixed.
today is the date fixed, my lord.
Yes. Make a prayer before that.
I communicated the
What is the application you have filed there?
my lord.
I'm keeping it at 2 p.m. Bring that application there.
This is the letter which I forwarded to Mr. Learned Advocate, my lord. I forwarded it through WhatsApp, my lord, annexing the cause list. And
this is your letter from there.
Yes, my lord.
What is the petition which is being filed? Get a copy.
My lord, according as per my communication, the petition is being filed before the learned trial court below, my lord.
In the
This is what
petition, something more will be written there. Please give me that photocopy of that. I'm keeping it at 2 p.m. What petition you are going to file there? Please give me a photocopy of that.
My lord, the petition is as per my communication, my
Let
lord.
me see.
My lord, I'm just contacting the learned advocate, my lord. Kindly keeps it at 2, my lord.
2 p.m. now.
My lord.
So you are the plaintiff. You should be eager to do your.
I'm ready and willing to conduct my
medical.
case, my lord.
The documents which you have produced do not inspire any confidence.
My lord, kindly grants me 2 months time, my lord.
Make that prayer before the learned trial judge. That you will
in
give
default,
evidence.
my lord, necessary
Sir,
order.
if you want time, make a prayer before the learned trial judge.
This is the order. In default, necessary order would be passed. So
now you are saying that within 2 months, make that prayer.
my lord,
If it is rejected, then it can be.
kindly keeps it at 2, my lord. Let me come back.
Application for expedition hearing of a title suit number 585.
Expeditious disposal of title suit. What is the stage of the suit?
Is not yet framed. There are 3 applications made.
7172 disposed of.
That was filed on the 8th November 2021 and still pending. Another application on each.
You are the plaintiff. This application under Article 227 of the
Petitioner
I am for the opposite party.
and
Yes.
praying for an adjournment
I am
on the
Praying for?
praying for an adjournment on the grounds of the learned advocate for the petitioner. There's a serious family crisis.
Objecting to that.
Not objecting.
Reluctantly.
His wife is suffering from pituitary tumor and she is under treatment. They are visiting doctors, and this is the papers.
Madam, don't put the court into embarrassment. You are praying for adjournment. I can adjourn this matter, but don't pray for upgradation. That's
Only thing is that they are enjoying interim order, and the suit is at
they
the
are
stage.
enjoying the interim order.
Yes, the suit is at the stage of argument.
The
they are
stay is given till the end of this month. Till the end of this month.
They are
what is this matter?
They are paired for cross-examination of PW1 has been closed. They prayed for it.
Their prayer for cross-examination was closed.
Yes,
You are PW1.
Yes,
I'm allowing that.
This is a 2006 suit of a 2006 eviction suit on the ground of second default. And their defense has been struck off.
That cross-examination is a valuable right.
Yes.
I'm
Yes,
allowing that. So I'm directing the suit to be disposed of.
Your lordships allow that. The only thing is that their prayer for recall was allowed by the learned trial court. Only on the payment of 3,000 cost. They have not paid that. Thereafter, that has been
paid the 3,000 cost.
That is something, your lordship, the learned advocate will appear before this court and he will say what he has to say. Your lordship.
Madam, please take instructions in this way. It cannot be adjourned. It's at the, I'm allowing your prayer. 3,000 cost if you don't pay. Please take instructions, come at 2.
on the last occasion also, your lordship has said to take instruction in the matter.
Yes, yes. Please take instructions. 3,000 cost for this.
Your lordship, the client.
And not only that,
Yes, client. Yes.
The client, she herself is an advocate and she and her widow mother. There is no other person in the family who is earning.
So advocate cannot pay this amount.
Sir,
What are you suggesting, madam?
Your lordship,
Maybe
your lordship, may I? If they were in a good position, why would the
then let this order remain. Let her not pay this. Let this order remain. You did not pay anything.
I'm just saying.
You did not pay anything.
Your lordship, give
Your conduct shows. So if that is has to be granted, you have to put 2 terms. If that is not, you need not pay. But this, you cannot take one part and challenge the other one. You cannot say that yes, recalling allowed but not cost. So it has to be in one way. If you don't want, I will set aside. Yes, I will say you need not pay without the. Please take instructions. Come at 2.
Your lordship, kindly adjourn for a week. At least.
Not a
kindly
week.
adjourn for a week. Your lordship.
No. Not a week. Please come at 2 p.m. or on Monday. Whatever.
On Monday.
Thank you.
Then, can it be on Tuesday, my lord?
Why? Monday you have difficulty?
Monday I have difficulty.
Your lordship, Tuesday is overbooked.
Is overburdened. Then, madam, please come at 2 p.m. today. Please come 2 p.m. today. Yes.
Your
Please come
lordship,
2 p.m.
kindly
today.
consider Monday. At least the senior will be here. At least the senior will be here. He's visiting the doctor with his wife. What can I do?
You are saying Monday.
Yes, I'm saying.
He has difficulty. He is ready today. Do it today. So you cannot accommodate for one day.
At least he'll get the notice that the date is fixed on Monday. So he will come.
I'm saying Tuesday. You are getting one more day. You are taking time. Then you have to consider his convenience also. He's ready today. Now today you are paying for time. Monday you have to do it on Monday.
Tuesday.
You know, on the prayer of the learned advocate for the.
Number 25, your lordship, I am appearing by the petitioner. I am led by Mr. Chatterjee, who is appearing virtually, I believe.
My lord, I am appearing for the opposite party, my lord.
Yes.
My lord,
This
I am
is the-
praying some time, my lord, because this matter, my lord, Mr. Budhe Bhattacharya is appearing, my lord. My lord, he has some cataract operation, my lord, and post-operation some difficulty, my lord.
Who is appearing?
Mr. Budhe Bhattacharya. My lord, time, my lord.
For a long time.
Mr. Chatterjee, an accommodation has been sought for on the Mr. Bhattacharya has undergone a cataract operation, so post-operative some you want an accommodation for that. What do you say to this?
I'm the last person to oppose that. Last person. But kindly fixes a date, Milord. This is a suit for eviction. So any day, Milord, convenient to my learned senior friend.
Yes, when he will be available.
My lord, in last week of this month, my lord.
Last week of
Yes,
this
my lord.
month,
In the trial court, my lord, the next date is in the month of September end, my lord.
8th of September.
No, 8th of September end, my lord.
Oh,
22nd
September end.
September something, my lord. My lord, he said he's 27, 28, 29th, any date, my lord.
An accommodation, Mr. Chatterjee, learned senior advocate, appeal.
তারা বন্ধ পজিশন অর্ডারটা হয়ে যায় তারপরে
Yes, I'm coming after 5 minutes.
Grateful, Milord.
I'm grateful.
lordship. That is the difficulty. He's available on 16th and 17th.
16th and 17th. That way, fixing a date may be a difficulty.
Yes, your lordship always says so. That let it run in the list and let it take its own course.
Yes, I'm making it not today only.
Obliged.
Careful.
Your Lordship, for the petitioner in this case, I'm praying for not today on seniors ground, Your Lordship. He is currently engaged in courtroom number 35.
On the prayer of the learned advocate for the petitioner.
My lord, I am appearing on behalf of the petitioner.
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 Yes.
My lord, the opposite party plaintiff have instituted a suit for eviction against the petitioner defendant, and said suit was decreed in favor of the plaintiff opposite party. Subsequently, the petitioner challenged the said decree before the learned district judge Bardhaman. Subsequently, the said suit was transferred to the additional district judge fast track to Bardhaman, and subsequently the petitioner have filed two applications, 151 under section 151 of the Code of Civil Procedure and under section order 39 rule 7 Code of Civil Procedure. Under section 151 51 of Civil Procedure for repairing of his medical shop room, petitioner has only his livelihood for depending upon the medical shop, my lord. And the shop room, which is indispensable for protecting the life of saving draft, keeping in the said shop room. My lord, on 21st May 2025, the learned additional district judge fast track 2 court, after taking up two petition, my lord, only one petition have allowed order 39 rule 7 and not allowed the under section 151 petition for repairing of the medical medicine shop room, which is very much urgent for the petitioner, as is fully dependent upon the medicine shop room for his livelihood, my lord. Two applications.
Commission held.
Commission not held. And we have challenged this said order. Only one.
Which order you have challenged?
This order number 13 dated 21st May 2025.
Sir, unless the commission is held,
my lord,
so how can the repairing application?
Repairing and order 39 rule 7, two petitions have filed.
Maybe, but unless the commissioner files the report, then once the picture comes, then the repairing application can be heard.
My lord, repairing was very much urgent. My lord, kindly see.
Sir, that is according to you. Then the local inspection, why have you paid for local inspection?
Kindly, not only that, the learned additional discharge first track material order law, material irregularity, that the order 13 rule 7 and the appeal has been fixed on the same date, my lord. Kindly bottom the order, the bottom portion of the order. May I permit to read, my lord? It is the opinion of the court that it will be.
So it appears that you don't want the repairing.
I want repairing.
What is the next date fixed? I am expediting the hearing of the appeal. Appeal cannot be stalled.
The order
repairing local inspection, you want it to be stalled. Let it be stalled. I am expediting the appeal.
My humble submission before lordship, kindly allow the petition under section 151.
I cannot allow.
Date fixed for under section 151.
Sir, I cannot allow in their absence. You have to serve.
Yes.
I cannot allow this ex parte.
Yes.
So if you want,
I will 151. This is very urgent because I fully depend upon my medical shop since long, my lord. And
what is the date fixed for hearing of the appeal?
My date fixed for 17 June.
17th June is over. Now what is the next date fixed?
I want to. Well, allow me 5 minutes time when I take instance.
So I can direct you to serve, but the hearing of the appeal should not be stalled. That should proceed.
Well, section 151 Code of Civil.
That will be decided. That will be, sir. That will.
Sir,
this has no connection with the hearing of the appeal.
Kindly.
Sir, only stay is granted.
Submission before lordship. Kindly, you direct the expedite the appeal, but kindly date fixed for.
Unless the commission is held, you do not want that. You want both these to be heard together. That's the difficulty. That is why I am saying. Let the commission be held fast.
Only allow order 30 rule 7 and 151 application should be heard together. Kindly allow.
Sir, order 13 rule 7 has been allowed. What are you saying?
No, after commission report,
All right.
after
The
commission
learned,
report,
all right.
My lord, I appear for the opposite party number 1.
I am appearing on behalf of the petitioner, my lord. I am led by Mr. Shoptang Subhasu Landed, senior advocate. He is engaged in a continuing matter, my lord. I am praying for only
Madam,
not
please
today.
start. Please start. Otherwise, if it is adjourned, it will be adjourned.
No, my
Then
lord,
don't
kindly-
mention.
My lord, on
Please proceed.
Yeah, my lord.
My lord,
Please
on
proceed.
25th June, they proceeded with the matter and got an interim order, lordship.
Yes.
Lordship, in this matter, the Walkout Board, Kolkata Municipal Corporation
Yes, madam, please start.
party. I would like to use affidavit in this matter. There are lots of documents.
You want affidavit? Yes, I will stay, direct this matter to appear under the contested application, stay to continue. You file your affidavits.
My lord. My lord, Mr. Basu has come, my lord.
Yes.
Well, there are lot of things to be.
It used to be hard.
Yes, yes.
So in the meantime, don't do anything.
Too sorry.
Yes.
This is the 227 proceedings. Under my lord, the walk of act.
So Basu, what do you say? He wants to file an affidavit in opposition.
Please. Kindly allow him to file as it requires.
In civil division application.
It requires. My lord, party is asking for, my lord cannot start him out.
You want to file affidavit in opposition?
As instructed by my client. Lord. As instructed by my client.
When this matter is taken up for hearing, the learned advocate for the opposite party submits that Yes. None appears for the petitioner.
under section 25 and 7 of Guardians and Wards Act, and Lordship will find from page number 24.
What is the impugned order?
Lordship, there are no order, Lordship. I have also filed a interim application, Lordship, under section 12 of Guardians and Wards Act, Lordship.
What do you
But,
want?
Lordship, I want, Lordship, the learned jurisdictional court, Lordship, do not allow to move my interim application, Lordship.
If not
Lordship,
allowed to move, I could not follow you.
Lordship, I have filed this application in the year of 2023, Lordship. Till now, Lordship, my interim application did not hard, Lordship. Lordship, let them direct to hard my interim application, Lordship.
Where is your interim application?
Lordship, Lordship will find from page number 35.
When have you filed that?
Lordship, I have filed it before the district judge of.
Yes, when? Give me the date. When have you filed that?
Lordship, Lordship, I have filed it on Lordship, page number 24, Lordship.
What is the date I am asking you? Please give me the date when you have filed.
5th October 2023.
5th October to 2023.
Yes, Lordship.
That is section 25 and 7.
25 and 7, Lordship.
Yes.
And Lordship, I have also filed the interim application, Lordship, this date, Lordship, on 5th October 2023, Lordship.
Where is your application under section 12?
Lordship, page 35, Lordship.
When did you file this? Section 12 application?
On the same date, Lordship.
No. Show me that you have filed on the same date. You have not filed on the same date. It appears that you have not filed that application. You have not filed the interim application, sir. So this case is ready on 2nd of July. I am directing the miscellaneous case to be disposed of.
Lordship, kindly direct them to allow my interim application, Lordship.
You have not filed, sir, till date. Order sheet does not reflect that you have filed. This application under Article 227 of the Constitution of India is at the instance of the
My lord, I am for the petitioner.
Yes. Yes.
My lord, kindly come to the order, impugning order, my lord. My lord, the learned advocate for the opposite party submits that the applicant workman has filed photocopy of the some documents which has been marked exhibit, and out of this exhibit, one exhibit, that is the exhibit number 4, is the letter dated such and such, signed by Radhasam Jaishwal.
Yes.
My lord, Radhesham Jaishwal, in the letter pad and name as Radhesham Jaishwal, and the opposite party is surprising to know that the said letter bearing the signature of the OP.
Which page you are placing?
My lord, my impugning order, my lord.
Yes, impugn order, which page?
On our first page, my lord.
First page. Yes, which paragraph?
My lord, first, second, fourth, fifth, sixth paragraph, my lord.
Yes.
The learned advocate for the OPs.
Yes.
The learned advocate for the OP submit that the applicant workman has filed photocopy of some documents which has been marked exhibit, and out of this exhibit, one exhibit, that is the exhibit number 4, is a letter dated 11/10/2013 signed by Radhasam Jaishwal OP. In the letter pad name as Radhesam Jaishwal, and the OP is surprising to know that the said letter being signature of the OP, which has not signed, and the signature which the exhibit 4 bears under the rubber stamp is unusual one. He further submit that whenever the OP went for procuring order and purchasing new separate part of the market, the new spare part of the market, the shop was entirely in the hands of the applicant workman, and it might have happened that the letterhead of the OP might have been taken away by the applicant anytime from the almari without knowledge of the OP. And later on, the applicant used the said letter pad and the manufacturing the exhibit 4. The learned advocate for the OP prays for verification of the signature of the OP in the exhibit document, in that is the exhibit 4. As the OP is denying the signature on the said letter dated 11/10/2014, that is the exhibit 4, and prays for sending the same to the expert. My lord, next page, my lord, my application is rejected. On the ground, my lord, next page, my lord, on perusal of the instant petition dated such and such, the materials available on record, I find the instant case is pending since 2018, and the said petition has been filed at the stage of evidence from the side of the OP. After completion of the evidence of the applicant side, I further find that the OP has filed the instant petition raising the allegation as to allege forged of the sign of the OP to have been committed by the applicant workman. I furthermore find that the document exhibit 4, letter dated such and such, has been marked exhibit in presence of the OP without objection. I also find that there is no whispering of the dispute, the said documents in the written statement filed by the OP. And the written, no written statement I have not filed, because in the plain applicant has not taken this plea, which is about in the exhibit.
Where is your application for appointment of an handwriting expert?
My lord, kindly come, my lord, page 27, my lord. Page 27, my lord.
Where is the evidence by virtue of which this document was marked as Exhibit 4?
My the evidence, my lord, applicant evidence, as per applicant, they have marked exhibit.
Yes, show me the copy of the evidence.
My lord, not only that, my lord, they have not taken plea in the application. It is out of
Show me
plea.
their application.
My lord, kindly come to page, my lord.
That is beyond the pleadings.
Yes, my lord.
Sir, you were present there. In your presence, this document was marked as an exhibit.
My lord.
Sir, why did you not raise any objection?
My lord.
Once a document is marked as an exhibit, can it be expunged, sir?
My lord,
Cannot be expunged.
appellate court has examined power, my lord. If any wrong is there, my lord, if the applicant advocate is not.
What is the main dispute? What is the dispute?
My lord, they have dispute, my lord.
What is the dispute?
They have taken in the plane for area salary, my lord. Area
What
salary.
is the amount of area salary?
They have taken allowed
What
area.
is that letter? What does that letter say?
That letter says, my lord, kindly come to page, my lord. 20, my lord.
Yes.
Letter, my lord.
Yes.
They are saying that he is the partner and I have taken 1,50,000 from him. That is the vague allegation, my lord. It is the afterthought, my lord. My
This
lord.
application under Article 227 of the Constitution of India is at the You are appearing for the opposite party? Yes.
My lord, I am for the petitioner, my lord.
Yes. Yes, Mr. Banerjee, what is this impugned order?
My lord, in a suit for eviction, my lord, it was fixed for cross-examination. My lord, kindly, my lord, take some, my lord.
In a suit for eviction?
Cross-examination, my lord, was taking up, my lord, going on, my lord.
You?
The defendant.
Yes.
DW was.
Your cross-examination was going on?
My lord. My lord, kindly, my lord. kindly, my lord, takes up, my lord, order dated 8th
What
of
happened
May.
thereafter?
My lord, on one date I did not appear. There was a resolution of the bar. My lord, I am not going into it. I did not appear. My lord, it was fixed for, my lord. My cross-examination was previously closed. I was, my lord, directed to pay 1,000 for, my lord, further cross-examination. My lord, I did not pay that amount since, my lord, on that day resolution was there. My lord, cross-examination closed. That is also, my lord, not the difficulty. The court held, my lord, in a one-line order that since the defendant has not been paying rent, my lord, regularly in the within 15th of the month, therefore 7(3) is applied and the defense is struck off. My lord, kindly, my lord, takes up, my lord, order dated 8th of May.
8th of May.
My lord, the last order, my lord, my lord, initially, my lord, without certified copy, it was filed. Subsequently, my lord, certified
Where
copy.
is the order dated 8th of May?
The last order, my lord, in your lordship's brief,
Oh,
my lord.
last order is not 8th of.
The
Oh,
last
yes,
order
yes,
is 22nd of May.
No,
Yes, last order 8th of May. Yes.
8th of May. My lord, kindly sees, my lord, it's a 3-line order.
No, no, no.
2 days fixed for further cross-examination of DW1. Plaintiff present, defendant files Hajira repeated.
Yes, Mr. Banerjee, if you are not complied with section 7, defense has to be struck off. What is in that?
In my absence, something like yeah, it cannot be
complied with section 7.
No.
Section 7, my lord, initially, my lord, 7.
Not initially. Are you complying with 7(1)(c)?
My 7(1)(c), my lord, kindly considers, my lord, I made an application, my lord, subsequent to this, my lord. Well, this issue was never raised by anyone. My lord,
Did not be raised.
but I know, my lord,
Court's
7th
power.
Court has the
has
power.
to
After, my lord, court has the power, my lord, after, my lord, listening to the defendants. After, my lord, giving an opportunity of hearing at least the defendants.
Show me that you have complied.
My lord,
show me from here that
I have made an application, my lord, kindly, lordship takes up my application once.
Yes, show me.
I made an application in page number 30, lordship comes.
30.
30. But subsequent to this order, because this order was passed, I was, my lord, my lord, fell from the sky this order, my lord, because no one was prepared for this, the defendants. Because, my lord, kindly sees page number 30.
Admitted the default.
Admitted for 2023 default.
Yes.
23, my lord.
So for that, defense can be struck off.
My lord, at this stage, my lord, after cross-examination was held, opportunity was
At any
given.
stage. What's the stage? What's the bar? At any stage, it should have been done. It should have been done much before.
My lord, after opportunity, at least, my lord, an opportunity be given, my lord.
What opportunity? This is an admission. What opportunity? Can it be condoned, Mr. Banerjee?
Chamaria says, my lord, 7th, my lord, after.
So, supervisor also cannot help you. The reference also cannot come to your aid.
Kindly, only one aspect, my lord, kindly.
That's what Mr. Rai argued.
I was there, my lord, in the matter.
So you are there. So,
my lord, only considers, my lord, one aspect, Chamaria, my lord, specifically, my lord. If the language of Chamaria, my lord, we go into, my lord, it specifically, my lord, states, my lord, 7(1), it states, my lord, and the initial 30-day period. After that, my lord, the once, my lord, 7(2), my lord, the amount is determined, that 30-day and the extension, my lord, given by the court. My lord, it sort of, my lord, keeps mum on, my lord, 7(1)(c). 7(1)(c), my lord, the statute of, my lord, the language of Chamaria, my lord.
Judgment on 7(1)(c).
Statute is, my lord, the word couch.
Statute
couch.
is clear, Mr. Banerjee.
Clear and my
There may not be Chamaria.
my lord, and the word
Statute
use
is
and. That is completely disjunctive.
Shall. Mandatory.
Yes, my lord.
Lord, kindly consider.
Not as in 1956 Act.
Right, my lord. And the 15 days deed cannot be extended in any manner.
The court does not even say that I wish to invoke 7(3). Let the defendant, my lord, come and argue on the next.
Necessary. It's automatic. And you have admitted in that application.
Subsequently admitted. Subsequently admitted. So, when this order was passed, it was not admitted. Subsequently admitted.
But fact remains that there is a default. By your subsequent application, you have admitted.
Subsequently admitted.
So, and the problem is, my lord, default is not once.
What is the default?
In recurrence.
That is the default.
So this was your ground that 7(3) could not have been. What is the order under challenge?
Well, 3 orders have challenged. 8th of May order have challenged since my lord 7(3) was invoked on that day. Subsequent to that, I made a recalling application on 22nd of May.
There is no question of permission to adduce evidence of the deed. So it goes. Everything.
Well, 22nd of May order I have also challenged, and subsequent to that I made a 151 application. The application, my lord, I placed before your lordship just now. That was also refused. That application for refused in one line. Kindly sees the nature of the order, my lord. It's a one line order. All orders one line order.
What will be written in 3 lines? Same thing will be written thrice.
Lordship can always, my lord, supply.
It can be said in 1 line. 3 lines are necessary. This application. my lord, telling the fact. Yes.
Grateful.
Before I am for the petition, Lordship, I am praying for not today. Well, I am for the petition, I am praying for not today.
Yes, where is Mr. Haldar?
That due to some personal difficulty, he could not come.
Where is he? He has not come.
So, Mr. I do not have any instruction regarding Mr. Haldar, but the advocate on record, due to his personal illness, could
Where
not
is
come.
Mr. Haldar? Ask him to come. I am passing it over.
Sir,
Ask him to come.
Mr. Haldar is not available today, my lord.
Yes, yes, he is available. I've seen him. Yes.
Great.
Yes, yes.
Yes, my lord, in this matter, I am for the petitioner. There is a suit for expeditious early hearing.
Expeditious early hearing?
Yes, the
of what?
suit is the total
of what?
The suit.
Suit.
Because the petitioner filed eviction of licensee. In this matter, sole defendant appeared and contested to file the WS. He admitted that I am a licensee. And that stage, he filed 7172 application in the eviction of licensee suit. Therefore, I am paying for the application is pending since a long time. Therefore, I am paying for disposal of the suit.
Sir, is it maintainable in a suit for eviction of a license?
I know, sir. I know, my lord, but defendant filed with the trial court a 717.
Take appropriate steps. Take appropriate steps.
Therefore, I am paying for expeditious of the suit. Therefore, I am paying for expeditious.
Where is Mr. Shiva Prasad Ghosh?
He's on the way, sir. He's on the way.
He's on the way where?
Okay.
To court or to residence?
From state consumer to here.
The learned advocate appearing for the petitioner. Yes, Mr. Rai.
Judgment on admission in a matrimonial proceedings.
Order 12 Rule 6. Judgment on admission. What is the admission? So divorce to be passed.
Yes.
So it may be mutual consent, Mr. Rai.
That the suit was filed. I am drawing lordship.
So what happened? It was rejected.
Rejected.
What is the admission, Mr. Rai?
Yes, that's suit filed by the wife.
No, annulment, not divorce.
It is a suit filed for the annulment on the ground, my lord. 25 1. Sorry, my lord, I beg to be corrected, my lord.
Annulment So registration was not proper.
Registration of the marriage that only after paragraph 4.
Paragraph 4. Yes. Yes.
The marriage has not been consummated. Paragraph page 4 at the top, my lord will find.
Page 4 at the top.
It starts
Yes,
from page
yes.
3.
From the previous page.
Yes, yes.
Paragraph 5.
Paragraph 5, last line, so consummation.
Now,
Can you turn to my amended
who are you?
I'm the husband.
So this is the wife's application.
Wife's application.
Then where is your?
Yes, my lord. Can you turn to?
So you have admitted that.
Yes. That your lordship will find. Paragraph 6, page 22.
Paragraph 6, page 20.
That is the dealing with paragraph 4 and 5.
There is a longish 5. Paragraph number 5 is a longish one. Yes, paragraph 6.
Yes. May I read out for your lordship?
What did the trial court say?
Yes. I turn to the order 7, dated 7th May 2024. Not ambiguous, that it is unambiguous, not unambiguous. Not only, my lord, equivocal, unequivocal admission, but also the conduct of the parties to consider, and the Supreme Court going to that extent also.
No, Mr. Rai, your written statement is not necessary. What you have stated.
It is the wife's application for it is a non-consummation of marriage.
So I am saying your written statement, because Order 12 Rule 6 says admission of fact may have been made either in the pleadings or others. So it's wife's admission.
Admission
On the
non-consummation.
basis of that,
It is my written statement I am admitting yes. There is no non-consummation marriage. Otherwise, my lord,
you are also admitting that fact.
So it is a.
So it may not be necessary because it's have to go by the admission of the wife itself. Because where admissions of fact, admission has to be in there. So it's not that you have accepted or
No, it is the wife allegation.
Otherwise, it will be on mutual.
Yes, it is the wife who filed that application for
or a compromise or something. So it's not that you are wanting Order 12 Rule 6. So you have to go by only the statements in the plaint itself.
Yes, but the admission required to be made not by the parties from where it will appear. It can be degree can be made on the basis of such admission.
Yes.
Yes. So admission is the pleadings of the wife.
Yes.
Now admission required from my side to that I am not opposing. I am also admitting these are the facts.
If that is also not there, let us assume if it is not there, even then.
And also there, if I did not raise any objection.
Because your written statement admission will not help in Order 12 Rule 6.
Other way.
Because it's only the person who is admitting. Otherwise, it will be a consent or a compromise, both the parties agreeing to some terms. It's a different Order 12 Rule 6. I think it has to be only on the basis of the pleadings and other documents. Admission of the wife itself.
Yes,
not
here
your.
is the wife.
So your written statement is immaterial.
The wife coming forward saying is non-consummation of marriage should be declared nullity. Husband coming saying that, and 36 not filed yet to be decided on that ground, my lord, it is pending. My lord, can you consider this?
Oh, 36 not filed or filed, it's
It
pending.
appears the parties have not filed yet affidavits of assets liabilities for which
No,
the
but
court
application is pending 36.
36.
So, Mr. Rai, there are some line of
Yes,
charges
this is
which
that is why, my lord, I presented. Now, my lord, today, if your lordship can consider.
I'm directing that application to be distributed because
Once, if your lordship, what will create the problem, my lord, your lordship? 136 is to consider. Then what is the use? Ultimate, it is not an object. 25 is there or not under the Hindu Marriage Act. Mr. Provision for
Mr. Rai, it's pending. I can direct that 36 to be disposed of.
Otherwise, one of these sort of litigation, one of the party.
I appreciate that, but there are a line of
Yes,
decisions
yes.
which
What
say
is fallen from your lordship?
you cannot also withdraw. So if you cannot withdraw, your written statement can be looked into from a different angle altogether. So you are trying to frustrate that 36 by saying, yes, I'm admitting that. Yes,
It
please.
is filed prior to that. Be as it may, I am not on that. It was filed prior to 36.
Maybe. So
on that also. But today, my lord, the object is to get the for declaration that the marriage.
Then, Mr. Rai, you have to serve.
Yes, well, then is without service, well, it cannot be done anything. If it appears well, they want something, it can be
You are ready to give that.
Everything has been given. We have been given, my lord. So I put this also to myself. The prime object is alimony or
I'm happier. I'm sending to mediation.
yes, that will suffice the purpose.
The
That is
penalty will be appointed as well.
সবাই আছে তো কোনো চিন্তা নেই।
By the order
Makes us mediation or
please remind me that I have taken the name of Mr. Banerjee.
আমি ধরে নিয়ে আসবো
Yes.
Your Lordship, this matter is about the expeditious disposal of the medical test prayed by the petitioner.
Medical test?
Your Lordship.
What medical test?
The medical test of the respondent, Your Lordship. The medical test, the petitioner prayed for the medical test on 28/2/25.
Where is that application?
Your Lordship, page number 20.
There is order 6 rule 17 also pending.
Lordship, the order 6 rule 17 has been disposed of in the last order. Last order.
It has been disposed of.
It's a very small amendment, Your Lordship, in paragraph 19.
So that application is being fixed when? This praying for medical test?
The petitioner prayed for the medical test on 28th February. After that, on
what is the next date fixed for hearing of that?
Your Lordship, the next date fixed for hearing of the last date was 5/7/25, Your Lordship. And
so on that date, hearing did not take place.
Yes, Your Lordship, the hearing took place and the amendment petition has been disposed of. In the
That
last
is the amendment. I'm asking you with regard to the medical test, what is the next date fixed?
18/7/2025. 18.
For medical test?
Your Lordship, for filing the amended petition.
For medical test, what is the date fixed?
Your Lordship, no date has been fixed.
This application under Article 227 of the Constitution of India, application none appears for the petitioner at the time of call, no accommodation. আচ্ছা এটা আইটেম নাম্বার কত?
My lord,
Yes.
in this matter, I am for the petitioner. The suit is before the trial court. The suit is partition suit. The scheduled property already mutually partitioned. After that, opposite number 1 and 2 hearing filed a partition suit before the learned third civil judge senior division Barashan. The suit is pending 2022. Your plaintiff's age presently 83, near about. I am paying for expeditious disposal of the suit.
No, you have paid for expeditious disposal of order 39 rule 4. When have you filed order? When the application under order 39 rule 4 has been filed? This application under Article 2.
Sir.
Yes, Mr. Ghosh.
Seniorly.
There was an amicable settlement between the parties. There was an amicable settlement between the parties in respect to the properties as concerned. Well, OP number 1 and to being the plaintiff filed a partition suit against the defendants. Defendant number 1, that is petitioner people lost the age of 83 years.
But Mr. Ghosh, the service is substituted defendants. So unless they file written objection,
They have already entered appearance and filed.
written objection to the injunction.
They have already filed it.
Written objection.
Objection by defendant number 1 to 7.
So order rule 1 and 2 is also pending.
Yes, with 39 rule 4. Kindly, Lordship, in all this matter, kindly direction should be disposed of within a year. 83 years.
First, the injunction application has to be disposed.
83 years old.
Let it be first disposed of. This Yes.
If
Yes.
my lord, preliminary degree already passed, my lord, but final degree is not passed, my lord. So I made application, page 10, my lord, page 10, for disposal of this application, my lord.
Yes. Which order you are challenging? What do you want?
For final disposal of this application.
Final degree proceedings.
Final degree, my lord.
What is the stage?
Challenging, my lord, order number 31, dated 25 30.
This application under Article 227 Yes. Pass over. Next. Pass over. Next.
No, 45 I am appealing.
45 you are appearing. Yes. Yes.
There is a caveat, my lord. We have served the caveat. But I'm the plaintiff in a suit under section 6 of the Specific Relief Act.
This is a matrimonial suit. এটা ঠিক দিলেন নাকি কি দিলেন? This is what item 45 আপনি 46 দিয়েছেন। তাই বলুন। বলছে section 6 দেখছি matrimonial suit. Yes.
My lord, in the suit before the learned trial court, evidences were.
Since I'm not inclined to take up this matter on personal ground, this matter.
Lordship had appeared.
Yes, yes, next.
I appear on behalf of the petitioner. My lord, by the impugned order, my application under section 36 of the Special Marriage Act has been rejected. Lord, can you not comes to page 14, my lord?
Since I'm not inclined to take up this matter on personal ground, this matter. Pass over. Next.
My lord, this matter, Satyajit Talukdar appearing for the KMDA, my lord.
Yes. Yes, who is for the petitioner? Pass over. Next. Forty-eight, 49 একসঙ্গে তো।
My lord, item 50, my lord, I am appearing for the petitioners, my lord. My lord, item 50. My lord, am I audible, my lord?
Yes.
My lord, item 50, my lord, I am appearing for the petitioners, my lord. My lord, I mean led by Mr. Gupta, my lord.
Give us a copy, my lord.
My lord, they are not on caveat, my lord. They do not have a right of audience. They are not on
Do you
caveat, my
have
lord.
difficulty, sir? Do you have difficulty in serving them?
How
My lord,
can
I do not have a. I do not have a.
lodge a caveat? That means I don't have an right of audience.
That is their
My lord,
right. That.
At initial stage, but
my lord, I will serve them. Lordship will directly. I will serve them, my lord.
Serve a copy.
Very well. I do not have a problem. I'll serve them, my lord.
Yes.
I'll serve them.
What is the impugned order?
My lord, the impugned order, my lord, the impugned order was passed. It's in a commercial suit whereby, my lord, my right to file a written statement was rejected, my lord.
Belated written statement.
My lord, not related, my lord. That's the issue, my lord. That's the issue, my lord.
Statutory period, it cannot be accepted.
No, my lord, this is a transferred suit. This is not a commercial suit, my lord. This is a transferred suit. This was filed before the regular bench, thereafter transferred to the commercial suit.
The petitioner is to when this matter is taken up for hearing, the learned advocate
Your lordship has kept the matter on, my lord.
we just ordered chili chicken. It's a copy. But I'm sorry.
yes.
কপি দিয়ে আসতে বলেছে
50 or the earlier matter.
Yes, earlier one.
Serve him a copy. Yes.
But your
Next.
lordship is keeping it on Monday or
Yes, next.
Monday matter will retain its position.
51 who is appearing. Pass over next. Pass over next. So.
50. Item
has indicated, my lord, that your lordship will be taking only the fixed matters fixed for today.
Only the fixed matters, or that will be
No, the 2 p.m. fixed matters fixed for today, and any your lordship is rising at 3:30.
Yes.
Lord, because of us. Lord, may I suggest a date for a very urgent matter? Your lordship had heard once it's in the list, on which your lordship may not be troubled otherwise. 31st of July.
31st of July.
Most lawyers will not be wanting to trouble your lordship on 31st of July. 21st of July. I'm happy to come and do the matter, my lord, because there's so much of pressure. It's a state matter, therefore, my lord, I'm happier. Lord, I cite a number, Lord. 381. Your lordship had heard it with regard to the jurisdiction of the court.
381. So
the matter
who
going
is
on in
appealing
Delhi.
for the other side?
Lord, advocate from Delhi is appearing online. If your lordship fixes a date, I'll let him know. We'll communicate to him that your lordship has kept it on such and such date. He is appearing online from Delhi.
Mr. Shen, can you do one thing? Can you inform him prior? Thereafter, I can fix. Ask your juniors if you are not available. Ask your
Kindly give me leave to mention on a non-mentioning day, Lord. I'll speak to him and Lord.
Because without, I do not know whether
he may have some difficulty also. No, I will do
date.
that. Yes, Lord.
So tell me on that.
And 21st July, Lord, I will request.
You can choose another day.
So 21st July, because most people are not wanting to come to court on that day.
2nd of August is also one of the day which you can take up.
Already marked, Lord.
2nd of August.
Oh, 2nd of August is, Lord. 2nd August is a very bad day, Lord.
Why?
Shonivar, Lord.
Yes.
Shonirvar, Lord.
So that day, if you want, it can be fixed. It can be taken up also.
But compensation is very poor.
I think that will be a better day than 21st of July.
Lord, my wife has given me a lot of household things to do on that day.
So,
Lord, I'll tell
please inform.
My lord, at the cost of being reprimanded for troubling your lordship at this hour, my lord, may I have your lordship's leave to file a civil revisional application challenging an order passed by West Bengal MSc Council, my lord, which was served to me via email. I have not received the hard copy. The filing department, my lord, has stalled my application, stating that I need to get a hard copy, my lord. It was never served to me via hard copy. I have annexed the email and the attachment.
Leave to file with the copy of that order.
My lord, I'm grateful.
Under compelling circumstances, if your lordship kindly permit to mention one matter. On the WB West Bengal State Electricity Distribution Company is the petitioner. An amendment application has been rejected. Now, my lord, I mentioned the matter to your lordship directed the matter to appear in the list. Matter is appearing in the list. Now, what happened, my lord? Yesterday was the date fixed. We sought for adjournment. 5,000 cost has been imposed. Next date has been given 24th July. Now it's subject to matter, and if we don't pay the cost, defense will be struck off. If you
So it has been fixed, you said.
24th July in the court below. I mentioned
here you have said that it is fixed matter.
No, not fixed matter. If you actually fix any day matter before 24th July.
Where is that item?
It is appearing in the monthly list.
Please mention them. You could have mentioned it for upgradation on Wednesday.
But yesterday what happened, I don't know. May I mention on Monday matter? I know matter.
Wednesday. Yes.
Kindly remember matter Wednesday matter. Only thing.
I will forget everything. What will be written in the mentioning slip, I only look at that. I do not remember anything what you are saying.
Cost has been.
And I can assure you, I am going through each and every mentioning slip that you can check up.
Yes.
So,
Extremely great.
yes, call the list.
Well, the defendant number 3 also applicable the amount that is required to be secured. That is our challenge, that it is not a suit under that.
That I've decided. I've said That I have decided both these revision applications have been disposed of. That is the only modification.
That is the only. Please, your lordship.
HON'BLE.
Yes. Well,
My lord has asked me to submit the petition, and this is the petition which has been submitted, my lord. And as
Yes.
per instruction, my lord, 10 days time has been granted, subject to the modification of the order.
10 days time has been granted.
Only 10 days, my lord. This subsequent medical document was produced before the learned trial court below, my lord. This is the petition, my lord. Annexing all my letter, what I have handed over to my lord, along with the medical certificate, recent medical certificate, wherein the doctor has advised a month's rest, bed rest. That a month bed rest, wherein it has been advised, my lord, that has been annexed to that petition, my lord.
Mr. Nayak, don't rely on that medical document. I have seen that. If you want, I will ask your client to go to another hospital. I have seen the medical report.
75 years age.
75 years, you will be finding many lawyers over 75 years regularly come into court, and
a person doing
age is not a
daily household work, and my lord, a person doing nothing and sitting at a home alone, my lord, 75 age factors, my lord.
So 10 days time has been given. Where is the?
That is in verbally, my lord, dictated by the learned judge below, my lord.
Petitioner is directed. কেটে দিন পুরো সেন্টেন্সটা listen.
Correct the date of year of the order, my lord. 24 it has been written, my lord.
একদম উপরে লিখে দিন to the date. Yes.
These are the three matters.
Transfer, and the other one is
Mine is amendment.
Amendment, and another.
Learned friends is, I think, transfer.
I am not in the second matter. I am in the first and third matter.
You are not in the second matter. Why?
Second matter is below. My senior friend is appearing below.
Oh, he is appearing for your.
For my client.
I am up against. My lord, my request is, lordship kindly go sequentially as to the filing. So maybe 41 may be taken up first because that was filed first. 2024.
Ultimately,
First matter is taken up, so the issue because that pertains to that section 24 application.
So that is not, I am for.
The event as of now.
No, I am.
Section 24 transfer will go with the other orders.
Definitely. But in whatever way your lordship decides, my lord.
My request
so,
is lordship kindly takes up the 41, the last matter in lordship.
what is the challenge there?
Challenge is
Amendment.
amendment.
So amendment, irrespective of transfer, it can be taken up. Yes.
I am not pressing that.
You are not pressing that?
No.
So that's the best way. What you should have said that
I should.
41 ta din, 5
My instruction was to concede on that. But he filed an application for amendment challenging that civil revisional application preferred.
Let me see what is the nature of the amendment. Why
It was
you are trying
filed
to
as
concede, he is trying to withdraw. Let me see.
it was filed.
So 227 power is different thing, even if you admit
Yes,
and
it was filed as a.
But it's a very innocuous prayer, my lord, in the amendment.
My application, Mr. Mukherjee.
your amendment was allowed.
No.
Amendment rejected. But
My
the
amendment was
innocuous
rejected.
prayer for amendment.
So you wanted
Mukherjee,
that
please.
to be allowed. You wanted that to be allowed.
Yes, I am not pressing that.
Where is the application for amendment, Mr. Mukherjee? Let me see.
That is the first
Now,
application.
today I am facing difficulty, not today, some days. Both Mr. Banerjee is appearing, both Mr. Mukherjee is appearing. Very difficult to record in the order.
Lordship, a suit was filed.
Where is the amendment? Let me see.
I'm just telling you, my lord.
What is the suit for?
What is the amendment? The suit was filed as an ejectment suit. Amendment was sought to convert it into a title suit, just the name. Lordship kindly sees the impugned order.
Let me see the amendment.
Page 29 of my lord's brief. It starts. Schedule is at page 30.
Yes. At page 30.
So he does. So that's the only.
That's the only. I don't want to go into that. His evidence, my cross-examination has been closed. I am the plaintiff.
That is my application.
I am the plaintiff. My cross-examination has been closed. Challenging which my learned friend is here. I am the plaintiff. PW1 is closed.
PW1, that is his right to cross-examine has been closed.
Yes.
My right.
To cross-examine you has been closed.
After 5 days of cross-examination.
Have you filed any application for recalling?
No, my lord, what happened is, my lord, at that
Why it was closed?
yes, that point of time, my lord, the learned court, my lord, that my learned friend has already mentioned that expressed his opinion that there is no need of further cross-examination, that you are not going to succeed in this matter. That was the, my lord, opinion expressed in the open.
So you prayed for adjournment?
Yes, I prayed for adjournment because prior to that, these incidents occurred.
Which incident?
My lord, that I mentioned just now, my lord, the court has expressed mind that you are not going to succeed in your my lord, defense. So there is no need of any further cross-examination. Now, my lord, if that was the case, and
I think that is the ground under section 24.
yes, my lord, that is why we said that since the section 24 is pending, kindly adjourn this matter. Let the section 24 application be decided.
All right, Mr. Mukherjee, I am allowing them to cross.
Lordship kindly sees the nature of the cross.
Well, that
Nature of the cross, that will be.
yes.
Lordship kindly just.
No, what is your objection? According to you,
I
am trying to delay.
I am coming from Imphal. to depose.
All right,
One day only. Lordship, kindly sees,
Yes.
kindly sees the fourth page of the bunch I have handed over. Page number 4. 5 questions on one day. Second day,
that will not be allowed. One day you have to conclude.
second day, 3 questions.
One day you have to conclude, otherwise no.
Lordship, now, my lord, Lordship decides this next revisional application.
That I will consider.
That, my lord, I will have a right before the other court. If your lordship decides ultimately that the matter will be transferred, then, my lord, I will reserve my right to, my lord, take out the cross-examination in the next court. That will be my respectful.
All right.
That's
Let
why-
me take the other one first.
Yes.
Yes.
Because, my lord, my case is very clear.
All right, all right.
That since
Let me
court
take
has
the other.
expressed the
Let me
mind-
see, because that will be judgment whether it will be transferred from which stage to where.
It's not that, it cannot be de novo.
No, cannot be.
Cannot be de novo.
Yes, so let me decide this where it will go. So then it will.
But the general parlance, my lord, I must be, my lord, candid before your lordship that a bold allegation against a judicial officer is not a German issue for which, my lord, this can be transferred. But, my lord, kindly see, my lord, section 24
This is
application.
227 after
220.
After district
After
judge.
district judge, my lord, after district judge dismiss my application under section 24 of the Code of Civil Procedure. My lord, kindly comes to page 130. 130, my lord. In CO, my lord, 2194.
Niranjan Kha, this is
Not,
PM.
Not that preemption. Not that preemption.
Yes.
Lord, 130.
I was thinking whether
Yes.
that is still
Preemption.
continuing.
That's the famous, very.
Yes.
Lord, it's 130 page. Lord, if your lordship kindly comes to page 131, paragraph 5. Lord, may I place paragraph 5?
Page 131.
One, Lord. It's the continuation of my application under section 24.
This judicial officer is still there.
The problem remains, my lord. I'm just placing, and thereafter, my lord, I will not take much
131.
time. 131, paragraph 5 onwards, my lord.
Any allegations
Lord,
you
the
have
Rani-
stated?
Lord,
ভার্চুয়ালটা বন্ধ, এটা বন্ধ করতে, লাইভ স্ট্রিমিংটা বন্ধ করতে।
that he was in some difficulty.
Yes.
Your lordship desired not by the previous order, not the order last passed. By the previous order, my lordship desired that I produce the writ petition.
That you have produced on the last occasion.
Excuse.
Oh, you have produced your copy. I asked you to, because those were, the original slips were also there.
I have already taken steps to withdraw this writ petition. The matter has been mentioned before the coordinate bench and it is likely to appear on Monday.
Yes, Mr. Vadaji.
First of all, Milord, one thing I should be very honest. Milord, in the writ petition that is there, even today it is there. In the writ petition, Milord, in the original writ petition, what I have gathered, Milord, on a cursory glance, there is no averment regarding the pendency of the tribunal appeal or the previous proceedings. According to me, Milord, in my humble understanding, Milord, as an officer of court, I say that it is not a very good practice on the part of the writ petition. And I use the word with trepidation, Milord, it's a sharp practice. Why? Milord, because Milord, he ought to have disclosed the orders made by the division bench, which prompted him to take out the tribunal appeal. He has made an innocuous prayer in the writ petition. He has annexed a representation of 2024, sometime of March 2024, if I am not mistaken. And in that, Milord, he has prayed for regularization of the so-called construction. And he has come by way of writ petition for disposal of the representation. Incidentally, the matter was gone into by a coordinate bench of your lordship's court sitting in the article, this group 5 jurisdiction, and an order has been made calling for a report. That is the sum and substance. Now, today, in this revisional application,
Yes, yes.
Now, today in the revisional application, it is simply, Milord, what little that I know of, Milord, very little that I know, Milord, of this particular branch, Milord, the revisional application is directed against a particular order made by the tribunal, which has acted in excess of jurisdiction conferred unto it by law. Why? Because, Milord, the revisional application is directed against an order passed in the tribunal appeal, where, Milord, my learned friends, Milord, in the private respondents, they filed an affidavit where in page 44 of the revisional application, they contend in paragraph 8 that I had participated in the hearing before the hearing officer and had made representations. Now, my lord, this had an impact on the, my lord,
Mind of the learned tribunal.
yes, no, I won't say that. This had an impact in the mind of the revisionist, my lord, who is before your lordship, the petitioner before your lordship. Why? Because he had never participated before the hearing officer. And that is an admitted position factually. So he took an inspection. The records are lying there in the tribunal. He took an inspection and he found that there is a, I mean, the other day I was wrong that he found a representation of 14th of March 2022, which apparently discloses the pendency of some suit, which apparently discloses not anything pertaining to regularization or anything. He disclosed the pendency.
But you have not given that representation.
Yes. Now, my lord, this document is a manufactured document according to me. So I wanted to inform the tribunal that please initiate appropriate proceedings to ascertain the veracity and correctness of this document.
That can be done. That's a separate branch that can be segregated. That I will direct.
Therefore, please look into it. If they have taken this plea in the
what is your challenge in the? Let us forget for the present or keep aside 14th of March 2022.
But my only challenge is when I bring it to the notice of the tribunal that this is the application that I have filed, please have a look into it. And
what is the application you have filed?
The application is for initiation of proceedings under the appropriate.
No, Mr. Bhattacharya, that will be done. What is your main challenge in the before the tribunal?
What is your main challenge? Milord, the order whereby Milord regularization of my whatever illegal construction has been declined.
Where is that? Show me the initial order of the SOB.
Yes.
That your prayer for regularization was denied.
Milord, my prayer, I was not there.
You said that my prayer for regularization was denied.
My prayer, Milord, the SOP's order is there.
So you have challenged that before the tribunal.
I tell you, Lord, SOP's order was sought to be implemented by way of a writ petition carried by my learned private respondents. That writ petition and order was made by your lordship's court, which prompted me to travel to the appellate court, not the intra-court mandamus appeal. The appellate court, my lord, granted me liberty to approach the tribunal.
For challenging the SOB's order.
Yes.
Now, please come to the SOB's order.
Now, please come to page 36.
Yes. 36. I am at 36.
Now, before that, please come to 35 once.
Yes.
This was the writ petition that I was referring to, not 5225 of 2024.
That is their writ petition, yes.
At the instance of Tutul Chakraborty and others.
You need not trouble with that. Please kindly come to straight away to 36.
Details of unauthorized construction is an unauthorized construction of area measuring such and such, along with change of use under 416 of such and such square meter beyond KMC sanction plan, wide BP number this, infringing rules such and such, and unknown rules 133 and 134 of KMC building rules 2009. This proceeding was brought against Dulal Chakraborty and others by KMC. The allegation against unauthorized construction at premises number 92/1, Dr. Daudur Rahman Road and ward number such and such, and violating this. Relevant record information available with the file. Précis of the infringement statement from Borough Office are taken into consideration. Notice under 400 subsection 1 issued on 26/11/21. As per report of the concern, there is a complainant named Tutul Chakraborty. The accused is not mentioned. It is just Dulal Chakraborty and others. According to my supplementary affidavit, I appeared on the first day. And a proposal was mooted in course of hearing for regularizing the so-called construction. Be that as it may, as per report of the borough, area of total unauthorized construction, area of this. Now, the flat owners lodged complaint against construction at parking places, preparatory, etc. As shown in sketch, the entire front of the parking space is converted and walls are erected, which obstructs the free access from front of the premises. Dulal Chakraborty is the person responsible for change of use at first floor from residential to commercial. Considering the documents, I am inclined to pass order to demolish, etc., to change the use of first floor. Maybe
So you are affected by Part A.
Part A.
You are affected by Part A.
And Milord, the observation made.
So this is the affectation of your right. So you have challenged this. What is the ground of challenge with regard to Part A? Show me your ground of appeal. Is it authorized according to you, Mr. Bhattacharya? Is it authorized according to you, sanctioned, and other things?
No.
Then what is the basis of your challenge? What is the ground of your challenge?
Okay. Ground 4, I'll just show you a lot.
No, no, not here, before the tribunal.
Ground 4.
Page.
Sir, it is not there. It is not a part of the records here.
Ground 4 means?
No, ground 4 in the BT appeal.
Yes, where is that?
That is Milord.
Oh, you are, yes, tell me which.
Ground 4, ground 5.
No, what are the grounds? You need not say ground 4, ground 5. What are the grounds? On what ground you have challenged?
For the impugned. Copy on my please. What are you?
Mr. Bhattacharya, you can place that. No problem.
There
Mr. Bhattacharya, you need not read the grounds. Please tell me what is in substance your challenge
Milord,
to this.
apart from being an ex parte order, it also, Milord, alleged deviation could be considered for in terms of 400 subsection 1, Milord, as well as circular dated this. Milord, they say that it could have been regularized in terms of some corporation circular. That is one ground. Apart from the ground regarding non-observance of principles of natural justice. That is another ground. Then, Milord,
you are not the person responsible. So, Mr. Bhattacharya, only the person responsible has a right to participate. What right you have to participate in the proceeding under section 400?
My premises is in question.
Maybe. Act does not give you a right.
Milord, Act does.
From where have you got the property? You have got the property from the person responsible.
Milord, I have got the property from the
person responsible.
From the allocation of the developer, who has incidentally sold the same portion to some other party. That is another dispute. Now, rightly, wrongly, Milord, I have purchased it from the developer's allocation. That is one.
Show me the Kolkata Municipal Corporation Act. Who has a right to participate in the hearing?
400 subsection.
Yes, show me.
Milord, please see.
At whose instance the erection or the work has been commenced?
Milord, 400 subsection 3.
Yes. Yes.
Any person aggrieved.
Yes.
Milord, I can be, Milord, at least, Milord, by no stretch of imagination can I not be held to be a person aggrieved. I have to be held to be a person aggrieved.
But show me your right that you have a right. Everyone say.
My right flows from the fact that I am in ownership and occupation of.
Now, Mr. Bhattacharya, a developer makes an construction. He is the person responsible. Now he transfers it to A transfers it to B, so on. So who?
Some semblance of a right. The occupiers, Milord, cannot be held to have no right to maintain an appeal or maintain even a writ petition, because they will be ousted, Milord, in the event the order of the SOP is executed.
What is the document that you are in occupation of that parking space?
Yes.
Show me a valid document issued by the corporation, or the corporation knows that you are in occupation of that parking space. Show me.
Please. Please see. An annexure B to the revisional application.
Yes, page.
That is page 27. Mutation certificate granted in my name, commercial space on the western side, page 27. Sharbani Chakraborty, Bapi Chakraborty.
When this mutation was done,
This mutation is page 15 December 2022. Approval date kindly see on the right hand side.
yes, and
December 2022.
when the order of demolition was passed,
Demolition order. Milord, it is 5th December 2022.
so prior to that, demolition order is prior to your mutation. How do the corporation know that you are the occupant of that parking space?
Milord, please see.
Yes.
Milord, in the supplementary affidavit, Milord, please come to the supplementary affidavit that we have used.
How much time you will take, Mr. Bhattacharya? Because I have fixed one matter at 3:15. Yes, supplement.
Milord, on 23rd May 2022, Milord, please come to annexure Q to this.
Supplementary affidavit, yes.
Yes. Milord, annexure Q.
Annexure
Q.
Page.
Milord, I'll just give just 2 minutes. Milord, page 39. I received this notice.
What are the documents you produced at the time of mutation?
Milord, the title deed.
With regard to the sanction of that portion. That's the requisite document for mutation. Show me, with regard to that parking space, what is the document which you have produced that that's a valid sanction as a parking space? Show me. In the application, what are the documents?
Milord, just give me 2 minutes.
Right, it is a parking space. He has transferred to a commercial space. That is the case, my lord. It has been sanctioned as parking. Now
Commercial.
he has been converted to commercial.
No, the mutation is as?
Now commercial.
Yes.
Now, if
yes, Mr. Bhattacharya, that you are permitted to, that is used as a corporation sanctioned it as a commercial space. Show me.
Milord,
At the time of mutation, you have produced that document.
Milord, Milord, I have purchased it.
No, purchase you may have purchased. Show me your purchase deed. You have annexed.
No.
Show me your purchase deed.
What are deeds? Milord, there are 3 separate deeds.
No, with regard to this commercial
Yes.
space. Give me that only.
Just give me 2 minutes. Schedule to go.
I forward people letter where they have made a schedule.
Yes, yes.
Milord, this is the schedule and this is the statement. Paragraph 2.
copy for the copy the
কিছু দেবো দেবো না দেখা
copy
দেবো না See?
18th of August 2020 you have purchased.
There are 3 separate deeds, Vinod.
Yes.
Initially,
show me that sanction with regard to that space as a commercial. Show me the plan.
I don't know.
Then
It is with the developer.
Yes. So Mr. Bhattacharya will be purchasing without getting the documents, without verifying as to what is the sanction of that, whether it's legal or illegal, we will be purchasing that. And you want the court to believe that. If you purchase that with your closed eyes, you will have to suffer. Unless Mr. Bhattacharya, you can show that this was a commercial,
I will request,
was sanctioned. So
I will request my lord, not to go into the, to that extent.
Why?
Because if any observation today that would affect ultimately in the event, assuming, let us take it for the sake of argument that your lordship is not inclined to interfere with the order under revision. Then, in any event, the section 5 application would have to be dealt with independently of any observation and would have to be decided. Would have to be decided. And any observation made by my lord would have a bearing to the ultimate decision in the tribunal appeal. Because today,
Mr. Bhattacharya, only one thing.
No, your lordship is correct. What is falling from your lordship, I am not. But today, that will preempt a decision in the appeal. Kindly visualize that angle also.
But I will demonstrate from here what he has done.
Mr. Bhattacharya, this writ petition is an admission of the legal construction. I can treat this as your admission itself.
Yes.
No necessity of that appeal itself.
Absolutely.
Once you have paid for regularization, illegal construction, you have admitted that.
Page 19, he himself admitted representation.
That is why I wanted this writ petition. And I have seen your representation. Once you have paid for regularization, what is regularized? So an unauthorized construction will be regularized. So what's wrong in the order? So there is no...
Come to us, Milord, at a stage when everything is already spoiled.
The difficulty is that, Mr. Bhattacharya, the appeal, there is nothing. So regularization, what we are saying, that there is a notification or a rule, whatever it might be, or a notification circular, which allows regularization. That's a different thing altogether.
I would have never ever advised someone to file a writ petition with such a document, which will eventually have an impact in my opinion.
And Mr. Bhattacharya, you know the law. Even if you withdraw, these admissions will remain forever.
The corporation, and moreover,
not in the corporation, will remain forever. Court of records, it remains.
No, I will prefer something more. Why, my lord, initially when revision was filed, everything has been suppressed regarding writ petition. When I pointed out that
instructions, I'm keeping it in the next week.
Instructions regarding
that I do not know.
Withdraw করবি না আমাকে টাকা দিবি সেটা বলছেন.
Only thing, Milord, only thing is, Milord, only thing. Kindly decide the matter either way too. I am not, Milord, going.
No, because there is one fixed matter. That is why. That is why I'm telling you.
We will continue with the appeal, Milord, irrespective of the document. Let the order be set aside to the extent of costs.
No, my lord, not that. I will prefer cost from here. Why, my lord? Initially, when he filed the revision, very well. But kindly visualize one thing. When revision was filed, everything has been suppressed in writ petition. That's why kindly see, my lord, kindly see the first order of your lordship. When the revision was filed, nothing has been stated about the writ petition.
All right. I will. If you want to make something, I will hear you.
But if your lordship delete that cost part, kindly direct the appeal to section 5 will be decided.
No problem. The 14th March 2022 document, if it is a document,
Mr. Bhattacharya, conduct shows.
For his
conduct is.
I will pray for cost, my lord.
You have suppressed everything in the writ petition.
Absolutely.
100%.
So why the court will believe in your statement that representation, nothing. Something, some bona fide has to be there. Some bona fide has to be there. Everywhere suppression.
100%. I cannot say something, Milord. There is no doubt that, Milord, in the writ petition, at least in the 226 petition, Milord, there should have been every candidate.
You wanted to only take an order saying that, yes, please consider the regular.
Milord, I use the word with repetition, that is sharp practice. It is
that is always there.
It is not
regularization that you can make that prayer.
Milord, Mr. Mukherjee is murmuring, Milord, আমার বিফটা ফেরত দিয়ে দাও উচিত ছিল। Milord, I do not.
আমরা কি শিখবো?
তুই তো আমাকে শেখালি রে।
Have you concluded or you want to make any further submission?
I don't think, Milord. না কাগজটা কেন বের করবেন? কাগজ কাগজের মতন থাকবে, তুমি ওখানে গিয়ে সাবমিশন।
So I'm recording that you have made your submission.
I do not want to add anything beyond this. Whatever is there is.
All right. Hard
আমাকে ছি বলছিস?
Yes. My lord, this is the additional affidavit to supplement my limitation. Limitation, why? Your lordships on the last date had order of 2016 you are challenging after 9 years. My lords, what had happened? Why? My lords, wait, what is the order under challenge? My lords, the order, what had been passed in 2016, holds all the directors on that given date responsible for the functioning of the company under the SEBI Act. Now, my lords, why I am aggrieved with that order is that thereafter, my lords, the company was pursuing appeal. It was continuing. I was under the bona fide impression, because I had left the company, that the appeal has been preferred and is continuing. On December 2024, it transpired that the company has withdrawn, or whatever has happened, all its appeal. So I am rendered remediless. Now, I was in the company from November 2013 till April 2014. The so-called alleged offense took place between 2012 April till 2013 April. The notice was issued by SEBI to the company in July 2013. The company replied, giving the name of all the directors and promoters in August 2013. I was not there. Now, my lords, all I was trying, keeping aside the limitation for a minute only, my lords, as your officer, my lords, under section 24 of the SEBI Act, if your lordship says the act is very, very clear. No, show me the order, which order you are challenging. Please yes, my lord. Your lordship will find the order. Which is the order under challenge? 1st of March 2016. Yes, my lord. Page 86. Yes. Yes. My lord, in this order, your lordship may kindly for a minute be pleased to turn to page 87 for a minute, the bottom portion. The interim order advised the company, the name of the directors, including the petitioner, to file the replies and indicate whether they wish to avail an opportunity to personal hearing. The interim order was forwarded to the noticee by SEBI letter dated 11th August 2014, and the same were delivered on all the notices. The notices filed by the reply by letter dated September 2, 2014. Inter alia, the following submission.
Regarding the petition, it was submitted that she had submitted a resignation on April 15. She did
So
not.
this is the direction. Kindly come to page 98.
Page
These are the directions.
These are the directions, my lord.
Yes.
Now, my lord.
So now what happened after this?
Page 98.
Is the order passed by the whole time member of the SEBI?
My lords.
So against that, what happened? Any appeal preferred?
Against that, appeals were preferred.
Yes. So take me to the appellate order.
My lords, a short list of dates.
Yes. Yes.
Copy list of dates.
Yes. Where is the order of the appellate authority?
Appellate authority order.
It's a tribunal.
It's a tribunal, man.
Yes. Which page?
2020. 110 to 118.
Yes.
With appeal number 231. My lords, by this time, though my name was referring, but I was actually technically not there. So here, what they do is, at page 112, this tribunal, after recording the statement of the council, disposed of the appeal, directing the appellant to submit a concrete proposal for sale of the assets, and if such proposal was made, SEBI would look into and pass appropriate orders. My lords, what had happened after this? The company had 5 assets which were sold off. The principal amount in contention was recovered. Much more was recovered. Thereafter, the petitioner moved because her assets by that time got frozen. She moved the tribunal again, and the tribunal, by an order dated in 2022, defreeze those accounts. SEBI came against that order to Supreme Court, and Supreme Court said, no, let it be again frozen, and you go back to appellate tribunal and you argue your case. During the course of those arguments, in December 24, it transpired that nothing is pending so far the company is concerned. Now, what I was trying to canvass, my lord, only for a minute, if your lordship may kindly see. Section 24 of the SEBI Act, based on which this entire thing is.
No, please kindly come to page 114.
114, my lords.
114.
Yes, my lord.
You are the third appellant in that appeal.
Yes, I was there.
So you are heard and this order was passed.
My lords,
24,
section 24. My lords, this order was passed. I'm not disputing. As your officer, my lords, I will not. I will never.
After this, where is the scope? You are heard. So did you challenge this order?
No, my lords, what had happened? This was done by the company. Yes, my name was there. It was continuing.
There were 3 appeals. 2 appeals were withdrawn.
2 appeals were withdrawn and 1 was.
Your appeal was decided on merits. Your appeal was decided on merits. That is page 114.
Page 114, my lord.
Yes. All your points were considered and decided. So you had the full opportunity to.
My lords, this then finally comes in my favor.
Yes.
This comes in my favor.
Yes. So no use going back to 2016.
No.
So no use going back to 2016. So what remains to the 2016 order?
My lord, only for a minute for my satisfaction. My lord, if your lordship will kindly see for a minute.
Sir,
only.
can I go back to that? Because the order passed by the whole time member has been merged with the tribunal's order. So if that is so, there is no separate existence of that. So I cannot entertain that.
No, my lords, your lordship is absolutely right. All I was, my lords may only hear me for a minute. What does section 24 of the SEBI Act says? No, this is not the. This is the Act. Regulation Act. Offenses by companies. Where an offense has been committed by a company, every person who at the time when the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to proceeded against and punished accordingly. So, my lord, this is what the section says. This is how the Act goes. My lords, for a minute, let me presume I have gone wrong in every which direction. The case or the case made out by SEBI cannot be pitched higher than what the law lays down. I was neither a director nor a promoter, not anybody in the company, no way connected on the day the offence was committed. Malad, the offence was committed, your lordship may kindly see for a
Sir, I cannot go back to that.
No, Malad.
Because after that, that order was challenged. 2016 order, according to you, no order could have been passed on that. After 2016 order, an appeal was preferred. In the appeal, all of you said, no, we want to comply with that. Time was given to comply with that. Thereafter, not done. Then separate attachment order and other orders were passed, which was challenged in tribunal. So it's the second round of litigation. First round, you said you will comply.
What had happened is they withdrew, saying that we would like to go back to the tribunal. They went back to
withdrew. You said that we want to comply with that.
Comply
please kindly come to this order. That order has been recorded. So,
but that was made by the company. Might not be that as it may be.
Maybe, but you had the opportunity. You could have raised that point that I was not part. I'm not bound by that 5th of August.
I was raising this issue before the tribunal now. When the tribunal said, sorry, you cannot raise this issue because nothing remains pending. So far, the company is also concerned. Man, that's where the difficulty is starting, my lords. I was raising all these issues before the tribunal. I understand what is falling from your lordship. So at that juncture also, my lords, I had tried to canvass my point before the learned tribunal that possibly section 22 of the Limitation Act to an extent comes because I was neither a director.
No, that submission was not made.
That submission was not there in the plea.
So if that is not there, so it's barred by res judicata. You ought to have taken, not raised. You cannot raise that.
What I was humbly submitting. Subject, absolutely, I'm in your lordship's hand, my lords. I cannot go beyond a limit. My lords, when the tribunal gave permission to the company for defreezing of selling of the company assets. The company assets started being sold. At that juncture, no action was taken so far I am concerned. There was nothing because these assets, also so-called assets, they are my gifts to me by my late parents. That's not part of any earning that I have made. They are no way connected with the company. So there was nothing.
Because you are protected. Please kindly come to page 118.
118, my lords, I know.
So your rights have been protected. Paragraph 13, nearing the middle.
Yes,
the appeal of the appellant number 3 is accordingly dismissed with no order. We, however, observe that the assets of the appellant number 3 will only be utilized if the assets of the company is insufficient to repay. So according to you, now the assets have been sold, more than the principal amount has been realized. So your rights are not affected.
My lords, what is happening now? What the submission they made before the learned Honorable Supreme Court, that it was 1 crore 13 lakhs or whatever the principal.
Yes.
They have recovered around 3 crore, but now they are cumulatively multiplying a multiplier system, and they say the total outstanding even now, despite the 3 crore recovery, is 5 crore. Now, because it is 5 crore, nothing left in the company.
So that's the different thing. So that issue, that order has been set aside. Page 119. 119 has been set aside because against that SLP was preferred. The Honorable Supreme Court has remanded, set aside that order, saying that it's not a non-speaking order, and to
your lordship in that event allow me to withdraw. I can possibly file an order, a challenge, whether maintainable or not. Your lordship will decide it then, as against the amount they are now claiming, because that's an
because the Honorable Supreme Court has remanded the matter back to the tribunal.
Yes, my lord.
Because and after setting aside the order dated 14th of June 2023, and you are also a party before the tribunal. You can make your submissions there, or if you want, I can give you leave. You can
I would be grateful, my lord. So that portion.
Thank you, sir. Sorry, because yesterday you were there, but it could not be.
My lord, I can understand. Your lordship
any application? What is Can 1?
Can 1 is a supplementary.
That supplementary affidavit I handed over to your lordship.
This
that
is
limitation.
Application. So
My lord, that can
Disposed
also
of.
disposed of.
Scan 1 disposed of.
I'm grateful.
Thank you, sir. Any other matter?
Item number 22, my lord, was fixed, pleased to fix the on 18, my lord. 18th, I have some difficulty, my lord. I won't be in town, my lord. But kindly make it on 17th or after 18th, my lord, any date, my lord.
18th of July, I have made it.
Yes, my lord.
21st of July?
Yes, my lord. But there is no adverse order. 21st or 22nd?
22nd of July. What is your item
Item
number?
number 22.
Item number 22 is 22nd of July. Yes, anyone?
Lordship,
Item number 285.
285. Want to move?
Yes.
Din. 285 ta document.
But other side is good. Other side has.
You are for the petitioner.
For the petitioner, item number 47.
Oh, other side is not here.
No.
Then how can it be done? The
Item
Banerjee,
number 47.
no caveat.
No caveat. This is a direction for early hearing of the miscase.
47 din.
From 2000 to 2025. The miscase is
Miscase under what provision?
under section 4 of the Partition Act. For direction to the trial court for early hearing of the miscase and connected applications.
Mr. Banerjee, the number of civil revision applications for expeditious hearing are being filed. No matter in usual course will be taken up. Throughout West Bengal.
Yes, sir.
In 2004, application has been filed. That application is still pending. The matter is being adjourned on the prayer of the opposite party. And this matter is adjourned day by day.
No, Mr. Banerjee, summons was directed to be served. Has it been served? Unless they appear, how can it be expedited? The miscellaneous case is not ready. There was a direction, last order says, direction to serve upon the added defendant.
That copy has been served.
Where is the
copy has been served?
It's otherwise ready for hearing.
Ready for hearing.
I'm recording your submission. Ashun, this application under